Today is, we'll have it on 18th itself.
Oh, Lord.
Reopening. Okay, 18th.
Interim order is there.
Para interim order passed earlier to continue till the next day of listing.
Lord.
Instead of 18 lot, can it be on 22nd lot? I have some.
22nd, okay, no problem. 22nd.
Lord.
Okay.
Item 12.
Please, your lordship. Here, your lordship, we need to obtain instruction regarding the GST number, your lordship. Verification
Yes, yes.
regarding GST number.
Yes.
And in this regard, your lordship, we
Where is the petitioner?
need to file our affidavit, your lordship.
Okay, none appears for the petitioner on call. Full stop. Para Miss P. Das, learned counsel appearing for the BTC. However, submits that instructions,
Await.
complete instructions are awaited. And accordingly, she prays for some time. Full stop. Para list after 2 weeks, 2 weeks to enable filing of affidavit by the contesting respondents.
DPO.
Is there any interim order?
Yes, your lordship.
Para interim order passed earlier to continue till the next day of listing.
DPO.
Mr. Devnath, you are appearing for? The department. The Sri Devnath, learned standing counsel. PNRD is present. And you?
Respondent number 7.
For your name?
Yes, Burwa.
For? Who is 7?
Private.
Oh, along with Sri S. Barua, learned counsel for respondent number 7. Okay. Again, 13.
My prisoner matter to be taken after some time.
I request some time, madam.
Oh,
Item number 4, madam.
yes. Can we take this for final disposal?
Yes, sir.
Is
There's
it
an
possible?
interim order, madam.
Okay, we'll try.
This will-
Okay, we'll try. Okay. नाम लिखवा नहीं थे क्यों?
Your Lordship, an item, I'm sorry, Your Lordship, I missed the.
We'll have it after 2 weeks.
Chairman.
Which
Mr.
matter?
Nayakan. Mr.
Which
Nayakan.
matter?
Beg your pardon?
14.
Yes, my lord. That land building permission.
Okay. Yes, 14, what is this?
I have, it is regarding land permission, building permission, my lord. I have
Okay.
prepared a short note. Yes,
Now,
my
can
lord.
we take this for final disposal?
Yes, my lord.
Then we'll have it after the top of the list matters. There are 2 your matters also.
My lord, it will not take much time,
No,
my
no,
lord.
no,
If your lordship kindly
We
go
can't
to it.
give preference to a matter of 2023 over to 2012. We'll have it for disposal, but after those matters.
After
Those matters were on the
matter.
top of the list. We have just
Top of the
deferred it.
list, my lord, item 4, my Mr. Kolita is also there. Your lordship may take up.
We'll take up, but there is item number 3 also before that.
Okay, my lord.
We'll take it up after in.
After some time, my lord. Yes.
Mr. Nayak, please be there. Okay, next. 15 to 17. Mr. Sharma, what is this?
Your Lordship, these are tender matters. There's a conditional stay operating, Your Lordship, which states
Other
that
side, Agriculture Department. Who's their Agriculture Department? Mr. Chaudhary,
my senior counsel,
B. Chaudhary. Mr. Borua, Agriculture Department.
Madam, Mr. B. Please, on his payment.
Mr. Sharma, are you arguing for final disposal today?
in fact, Your Lordship, there's been current development. The technical evaluation has taken place. And the price bid is yet to be opened because my learned senior submitted that once it is opened, it's an automated system.
Okay, now we had made some observations.
The issue is, there's only one issue.
No, we remember this case.
My
You are
senior-
supposed to place a seal cover evaluation, results of the evaluation.
My lord.
isn't it? That same case.
Yes,
You are the manufacturer.
I'm the manufacturer, which requires now me to have supply experience for government undertaking paper.
Now, we said that if you are out on the price bid, then we don't need to adjudicate the
But
issue.
there's also a further issue that might need to be adjudicated by your lordship. Piggybacking on our order, which is general order that all the manufacturers will be permitted to participate,
Hmm.
subject to that stipulation from this honorable court. Now, there are other parties also who have joined the fray. Now, the price bids are yet to be opened. The lordship might adjudicate the matter to a certain extent here, whether the requirement of a supply experience for government undertakings is required, because it's not just the petitioners. There are other parties also who have actually gone with the flow.
No, let them produce the price evaluation
Yes, yes.
sheet.
If they can do that,
After that, we can, we will take a call.
yes,
Okay.
yes,
Ask Mr. Chaudhary to come, okay, after a while.
yes, sir.
Take a first. Let the time pass over the letter from time. This matter is said by second, so the next court number.
Who is for the other side? Tiduri,
Not video read. That's
you are for the IOC.
for the.
Oh, Tiduri, they are no longer here. Is there any other set of counsel?
Yes, sir.
Who?
R Sharma.
R. Sharma. Name shown or not?
So,
Name shown. R. Sharma. Not shown. Not shown. Is there any interim order?
no, no.
Then why isn't the registry showing the name of R. Sharma? R. Sharma, Randeep Sharma, or who? Rajeshwar Sharma?
Randeep sir.
Hmm?
Randeep sir. But he is present. Court.
He has to know about the matter. His name's, if he is there in the court, that's a different thing.
Today we have filed I
For?
for temporary arrangement.
For?
Actually, for temporary arrangement of the catering service. So,
Okay, we can have it on Monday. Ask Mr. Sharma. We'll ask.
actually, we have urgent electronic it next week.
No, in absence of the other side, we will not be able to pass orders. We can have it tomorrow also, no problem.
Tomorrow, Lordship.
But you have to call Mr. Sharma.
Okay.
We'll pass orders today so that he is available tomorrow.
Okay.
Call him. Or any of his colleagues. Mr. Dasgupta, your matters will be arguing for final disposal.
No, it was last 17 order.
Oh, no, you'll not argue for final disposal. But will you take time for argument?
No, it can be fine.
No, will you require some time?
No, it will not be good.
Okay.
But the petitioner is not before. I'm the respondent, Lord.
Oh, yes. Where is Mr. Chakraborty?
Talk about, he is in court number 3 in my
Okay,
case.
wait for a while.
Oh, let it be taken up at 2. Only
Not at
simple
all,
order.
but we'll take it up. We have some matters in the top of the list. We'll take up those matters. You can come after some time.
All right.
Take your time. Don't worry.
Much obliged.
Item number 4 one. Two. Item number 2. Contra admission. Supplement. Oh, okay. Yes.
Lordship, may kindly be pleased to peruse the order WPC 6431/2023 passed by this honorable court.
Okay.
Matter relates to tender process, Lord.
Yes. Okay. What about the other case 4185?
4185, the same matter. Where it
No,
is
but-
not-
Take Lordship now.
4185 is also there.
Yes, sir.
Okay.
But Lordship, issue is that in 4185, this honorable court passed an order issuing notice on 4th of August 2023, directing the respondent state irrigation department to file the counter. 4th of August, today is 4th of January, 5 months gone. Respondent,
Yes, Mr. Upadhyay?
Lordship, I will file my.
No, you will file means what? Will is when?
Lordship,
You don't have the will to file.
I have
You
the
need to
will.
have the will to file.
In fact, I
Simply
received
saying
some-
that I will file or not there. We don't see the
Lordship,
will.
I have received some instruction, Lordship, which is not, Lordship,
No, 4 months, so if
5
it's
months,
5 months, it is not fair.
and Honorable Supreme Court insisting that early disposal matter.
No,
And
those
5
are,
months taken by
those are there, we'll take care.
2 weeks.
You are from Guwahati?
yes, Lordship, 7 days, 2 weeks, 2 months, 7 days.
Are you from Guwahati?
Yes, sir.
We'll fix a date so that he can appear.
Lordship,
But don't,
otherwise, Lordship, this,
don't-
this case is not maintainable at all, Lord.
That
This
is,
tender process, Lordship, matter become infrastructure. Already the process is over, Lord.
no, you file the
Lord,
affidavit at
Lord.
least.
Lord,
Let him know on what grounds you'll be making the arguments
Lord,
so that he
Lordship,
can make
my
a.
prayer is not tender matter. I am, my prayer is seeking your liberty to initiate criminal proceedings against the respondent public servant who is a superintendent, who entered in the pre-bid conspiracy with the was single bidder by giving him near work to 6.5 people. So there is a prima
Is it a
facie
single bid?
single bid. Prima facie there.
Sir Upadhyay?
2 weeks, Lord.
No,
Okay.
not two bidder, one bid.
Okay, have the records. Next time, if even if there is no affidavit, you have the records, we'll decide on the basis of the records.
Lord.
And secondly, the private respondent number 7 was also instructed by the Honorable Court, Mr. Manish Chaudhary, to file his counter, he did not file.
Who is 7?
And this
Lordship,
way,
whether service is the,
MP Agola,
whether service is completed or not to the private restaurant.
service, they manage something long back it was given.
Mr. Bhattacharya, you are appearing in person. You
Yes.
don't have the liberty to speak anything or everything.
Okay.
Managing and this thing, don't utter these words.
Okay.
This is a court system.
Sorry.
What is this managing?
Okay.
Do you know something about service? Simply issuing notice, will it mean service?
Sorry, sir. I beg your pardon. Beg your pardon.
We don't go by emotions.
Beg your pardon.
You are appearing in person, you are giving you some liberty, but don't take unnecessary advantage of it.
Lord.
Here, notice was not issued to respondent number 7.
In the Lordship 4185 notice was issued. 6431 notice was not issued.
In 4185, notice has been issued.
Lord,
Steps taken on it.
Let's second.
my friend.
Okay. We can do one thing. There's an office note of 3/1/2024, just yesterday.
Lord.
Where the service upon the respondent number 7 has been held to be complete. We'll pass an orders so far as 4185 is concerned.
Lord.
And Lordship, may I pray that 6431 may also be implemented respondent number 7, private.
We will do one thing. You write in 4185. This court, wide order dated 4/8/2023, had issued notice of motion pursuant to which Sri Upadhyay, the Learned Standing Council, had accepted notice on behalf of the official respondent numbers 1 to 6. Full stop. So far as service upon respondent number 7 is concerned, there is an office note dated 3/1/2024, as per which service upon the said respondent number 7 is held to be complete. Full stop. Office note. There is an order dated 3/1/2024 of the Learned Laws Ima Court. Para. And in view of the aforesaid development, the respondent number 7, service upon the respondent number 7 is held to be complete. Para, Sri Upadhyay, Learned Council, Learned Standing Council, however submits that instructions are awaited. Full stop. Awaited and praised for some more time. Full stop. This court has, however, noticed that noticed that notice of motion was issued way back on 4/8/2023. Full stop. Be that as it may, comma, and in the interest of justice, a further opportunity is granted directing listing of this case on, tell us, date of your convenience.
12th of
12th, next Friday is not possible. We'll have it on 19th.
19th.
19th of Friday,
Okay.
okay, 19th. And in, the other one, 6431. Sri P.K. Bhattacharjee, the petitioner is present in person. Sri N. Upadhyay, Learned Standing Council, Education Department, is present for the respond numbers 1 to 6, para. Wide order dated 6/11/2023. Notice of motion was issued. Full stop. This court has, however, observed that since the issue of maintainability was raised, comma, notice at that stage was not required to be issued to the respond number 7, full stop. The para. This court has, however, noticed that the same petitioner has filed another writ petition 4185/2023, which has been tagged along with this case. And in that case, comma, notices were served upon all the respondents. Notices were issued and served upon all the respondents. Full stop, para. In view of the above, and in the interest of justice, let notice be issued also to the respond number 7. Full stop. Let steps be taken by registered post with AD by tomorrow. List along with WPC 4185/2023. Full stop. Para. As observed earlier, comma, the question of maintainability of the writ petition is open. List on 19th.
My lord, in this case, we have filed an IA whereby, my lord, during pendency of the case, we are seeking leave of your lordship to make.
Sir
some-
Sharma, are you aware of this matter today?
My lord,
You are aware of this matter?
I'm sorry, my lord, I was held up.
No, your names were not there, are not there, you and your colleagues. There is a change in the earlier set of council.
Well, there's a change in earlier, but my instructing council has appeared.
No, it doesn't matter. No, if you are aware, there's nothing, no problem. No, you are seeking some sort order today.
My lord, I'm seeking a leave to make some alternative arrangement. Otherwise, it's a, my lord, catering service is stopped. My
Okay,
lord, there are
okay.
lot many guests and office staff are there.
Oh, and where?
And there is a
IOC.
guest house of BRPL, my lord. An unit of IOC.
Where? In Bongaigaon?
Guwahati, 6 miles. Now, a catering contract was given to my learned friend's client, the petitioner, my lord. Now, there is some dispute going on.
Okay,
Subsequently, my lord, it stands terminated.
okay.
Now, initially, the grievance was that the kitchen was not handed over, which is not correct. Kitchen was given on the very
No,
same.
Mr. Chaudhary, we may not go into the merits of
Yes.
this case.
All-
You want to say that
make
now?
some alternate arrangement
My lord,
till the matter is decided. my lord.
on the very basic of the contract, we entered into a contract with them.
No, Mr. Sharma, we are not going to make any observation
Ah.
to cause prejudice to either of the parties. Your issue, the dispute which you have raised, will adjudicate as per the merits.
Ah.
But now, this thing, guest house cannot run with a catering
The
service.
kitchen.
They had been running the guest house without a kitchen prior also, And they may give it to me, my lord. My only contention before my lord, that is why I'm here, is that
No,
let me run.
we'll fix, since you are here, we'll fix a date for our hearing. Until that time, you
Make
manage it.
some alternative arrangement. That's
You have a date of your choice?
My lord, if, my
The,
lord,
your contract was for, what was the tenure of your contract?
2 years.
2 years, okay.
years.
When did it start?
It started in May,
May of 23
May of 23. My lord, what has happened here
till 25 May,
till 25? My lord, what has happened here
yes.
is that by their own IA, if my lord, my lords may kindly come to the IA,
Hmm.
they themselves, they want to rewrite the contract.
No, those things we are not going to. Neither will say anything. Will not even enter into those aspects. Make a very simple observation. And we'll fix a date. Tell us a date. Mr. Chaudhary,
any date after 7th of February. Any date.
tell us. Third, three. We'll pass orders in the IA.
The IA.
K.N. Chaudhary, Learned Senior Counsel, assisted by M.S.R.R. Kakuti for the applicant IOC. Also heard three. R. Sharma, Learned Senior Counsel for the opposite party writ petitioner. Full stop. Para. The dispute raised in the writ petition is with regard to cancellation of a catering contract,
Yes.
which was for a period of 2 years from May 2023 to May 2025. Full stop. Para. The
30th April 2020.
The contention advanced on behalf of the applicant IOC is that since the catering service pertains to the BGR guest house
Yes.
of the applicant at 6 Mile, comma, some liberty may be granted to the applicant to have some alternative arrangement so that the guests of the, so that the, what do you call, guests aren't, do not have to face any problems, full stop. Para. Sri Sharma, the Learned Senior Counsel, submits that the entire writ petition can be heard instead of passing an interim order, full stop. However, the Senior Counsel has fairly submitted that the services in question are essential in nature, full stop. Para. Keeping in view the aforesaid facts and circumstances, and without making any observation on the inter se merits of the dispute, comma, it is provided that the applicant IOC may make alternative arrangements for providing catering service in the BGR guest house at 6 Mile, Guwahati. Full stop. The arrangement would, however, be effective till the next date fixed or till further orders to be passed by this court. Full stop. Para. As agreed to by the parties, list the writ petition for a final disposal
It
on.
can be on 13th February, madam, Tuesday.
My lord, I won't have you out. Listen, my lord.
Tell us the date of your consensus date.
Yeah. Yeah.
15th or 20th? 20?
My lord.
20 February.
Deep left.
I stand disposed of. This is in 3824.
My lord. Deep left.
All right.
Orders to material. How long will you take?
It won't take much time. It's an application for 17 days.
No, understood, but though it's a, what do you call, interim kind of a prayer, order will pass. But if you take time, then we'll take after the hearings are over.
No,
Or
no,
if-
it won't take much time. The only thing, my lord,
Hmm.
lot to make the pass now. Unless take 17 days.
Okay.
That's all.
So I have some instructions, but I cannot find it actively. Oh, yeah, okay.
Heard 3 S. Chakraborty, learned counsel for the applicant. Response number?
My lord, one.
Response number 1, who response number 1 also heard 3 A. Dasgupta, learned senior counsel for the opposite party writ petitioner. Full stop. Para. By this application, ID 1947. By this application, comma, the applicant has prayed for appropriate orders to be passed under Section 17B of the Industrial Disputes Act 1947. Full stop. Para. The writ petition has been filed against a judgment and award dated
21/7/2020.
order dated 1810, a first paragraph to দুবার লিখি না থাকবো আর full stop. Para. This court, wide order dated 18/10/2023, had issued rule and call for the LCR. Full stop. Para. This court had also passed an interim order to the following effect. Page 7, paragraph 7, quote. Para. 3. Chakraborty, the learned counsel for the applicant, response number 1, by referring to Section 17B of the Industrial Disputes Act, 1947, within bracket herein after the Act, has submitted that in case there is a stay of an order of reinstatement, comma, there's a requirement for payment of full wages to the workman. Full stop. Full wages last drawn to the workman. Full stop. He has also submitted that the prerequisites of 17B has been complied with by the applicant in as much as he has filed an affidavit stating that he is not gainfully employed. Full stop. Para. 3. A. Dasgupta, learned senior counsel, has fairly submitted that the application or that 17B, that Section 17B, that the provisions of 17B, Section 17B would be applied only if the workman fulfills the preconditions, namely to submit proof that he is not gainfully employed
By filing an affidavit.
by filing an affidavit. Full stop. Para. This court has noticed that such statement has been made
Paragraph 6 of this.
in paragraph 6 of this IA. Full stop. Para. In view of the above facts and circumstances and taking into account the objective of inserting Section 17B in the statute book, which was done in the by an amendment in the year 1982, comma, it is directed that the applicant workman be paid the wages last drawn by the respondent management. Full stop. Para.
From the date of that award.
From the date of the award. Full stop. Para. Since you want an early date of hearing, if you want. Okay. Have you filed your affidavit?
No, my.
Not required.
Not.
I
We'll allow
accordingly
it, no.
stand disposed of.
Obliged. The lordship has fixed any time frame for them to pay
They
that.
will comply.
No, don't worry. Oh, I have some other instruction, but I cannot place.
Yes, next.
Ablash.
My lord, the work orders has been issued. So practically, my lord, all the persons, including the petitioners, they have been given the work order. But I would say, my lord, the complaints filed by the petitioner can be disposed of. There is no bar for disposing. Because my lord, what I am saying is, the lordship will kindly say page 54. Page 54,
Hmm.
because there is a provision for filing objection.
Okay, you consider those
Yes.
objections?
And also page 40, page 55, clause 40, man. Clause 40, it says, bidders should know that ONGC may verify authenticity of all the documents, certificate, no information submitted by the bidders against.
Now,
the
why are you
tender.
insisting on this? If
No,
you
no,
are
because my
with
lord, some of the bidders, my lord, they have not given the manufacturer certificate. They have given the assembler certificate. So therefore, my lord, and they,
now,
and
since
they,
you have been given the work order, what
no,
is
no,
what
that's
do you
not right,
gain?
my lord, but there is no bar for looking into the complaints filed by the petitioner because they have also initiated. So that observation, your lordship may.
No
go.
bar.
No bar.
You will not issue any directions for you to
Yes.
consider.
One
You
of the
you will.
CVC the CVO otherwise, but we are governed by the CVC guidelines.
Yes.
The
We'll say
manual-
no bar. We'll say
no,
no bar.
We cannot possibly go into it
No,
because the
we'll
manual
say
says,
no bar.
Madam.
If you do
And
not
the-
go, not go.
and as far as the NOA is
Hard.
concerned, Malad, may I just point this out?
Yes, yes.
Now, we issued them a notification of the award. We said, Malad, this is issued subject to whatever directions may flow from this on these proceedings before this one. Now, in response to our NOA, Malad, what they have said is that we are not accepting your NOA. So you please kindly go ahead and withdraw and issue a fresh letter. They are not accepting our NOA.
No, no,
this
we are
award.
not there.
No, this is a letter from them.
Now the work order has been issued to everybody.
They have not
my lord.
accepted the work order.
No, no. Now we are. That is only because of the subject to the outcome. Now your lordship is.
So there is an interim observation to that
Now-
effect.
now your
We
lord-
cannot possibly dilute that.
No, now your lordship is going to dispose of the matter.
No. What about this letter, Mr. Das?
That
This is of
because
recent
the-
origin. This is of 28th of December.
Because of the pendency, Lisa, I'm not aware.
28th
Okay.
December. No, you have to take their instructions, Mr. Kolita. Don't embarrass your senior. Your client writes something else.
Okay.
You are not even aware.
This is the NOA that it was issued by the ONGC.
Kolita, take instructions. We'll have it on Monday.
No,
No, what you saying is very fair. We could have done it, but
Yes.
this letter may
if they
create
have
some
written some
difficulty.
letter, I must know.
Yes.
so.
Take instructions.
The notice
Monday.
of. award-
Okay. Hard free, BT Das.
My lord, let it be on Tuesday.
Okay. Only for this matter. Otherwise,
Yes,
we'll
yes.
close it.
they are
What you were
accepting-
saying is very easy for us to pass.
Yes,
Not a
yes.
problem.
Because the orders have been issued and the provisions are there to look into.
And
the
if,
complaint.
advise your clients, since you know what is the orders which is likely to be passed, advise your clients to withdraw these letters.
Yes.
Or maybe reframe these letters.
Yes.
Any orders passed by this
I'll-
court will
I'll-
abide. Okay.
Because I'm not aware.
Heard Sri BD Das, Learned Senior Counsel for the petition assisted by Sri K. Kolita. Also heard Sri B. Chaudhary, Learned Counsel for the ONGC.
ONGC, Madam, 125.
Para. This court has been informed that there are certain developments based on which this writ petition can be disposed of. Full stop. Para. However, to facilitate the learned counsel to take further instructions, matter is adjourned to be listed on Tuesday. Tuesday.
Deeply aware.
You can take this back.
26 of
Orders. Yes, Mr. Laskar.
Lord, regarding settlement of weekly market, my lord, in this case, my lord, notice was issued, but regarding.
Have you
that-
filed your affidavit for
No,
Dusty?
my lord, Dusty, my lord, As the settlement is up to July, my lord, they have not come forward, but let it.
Have you taken Dusty?
I have taken, but the petitioners.
You have not even collected the Dusty notice. What is this?
Only registered post, my lord.
You take Dusty, have it, we fixed an early date on at your insistence.
My
4th December, we fixed it today on the reopening day.
my lord, recently it was prepared, we are informed, my lord. As the settlement up to July, my lord.
That is the reason we had allowed, given
My-
liberty for Dusty. Take the Dusty service.
My-
We'll fix a date.
My-
Sri J. Laskar, Learned Counsel for the petitioner, submits that due to some difficulties, due to some communication gap, the Dusty notice could not be collected from the office
Right.
and consequent steps could not be taken. Full stop. Para also heard MS S. Borua, Learned Counsel, appearing on instruction of MS R.B. Bora, Learned Standing Counsel, BTC. Full stop. Para. Let the the petitioner is accordingly given liberty to take fresh steps for by Dusty for service of notice upon the respondent number 5. Full stop. The registry is accordingly required to make necessary change in the notice accompanying the Dusty service, clearly reflecting the next date, which is fixed on, yes, tell us, fixed on 22nd,
My
but do it,
lord,
22nd of January, 2024, full stop. Prior to the next date, the petitioner is required to file an affidavit in proof of such Dusty service upon the respondent number 5. Full stop. Okay. See, there's an office note of 3-1 yesterday's.
my
Dusty is ready. You have to go
my
change the notice.
Fine.
Okay.
obliged.
I didn't do some of the
May page your lord. My lord, this is an application against.
Mr. Borkotoki, Mr. Your matter will take some time. These are matters in the top of the list. You can come after some time.
Well,
Okay, then we can have some date. Is it a matter which year? 17.
the 5 meter,
No, doesn't matter. Don't worry. You need not come.
22 number.
Mr. Your junior will come. Don't worry. We'll accommodate you. When do you want? Tell us it. After a month. 2000 2017 matter. Where is Mr. Count? Okay. Okay. Sri S.K. Borkotoki, Learned Counsel for the petitioner, though present, has submitted that he is not well and has undergone treatment, full stop. He accordingly prays for some time. Full stop. Also heard Sri S. Count, Learned Counsel for the respondent number 5 and GA, and also heard Sri M. Chitti Agotadiba, huh? GA and S. Count, respondent number 5, full stop, para. Considering the aforesaid facts and circumstances, matter is adjourned to be listed in the 2nd week of February. Mr. Borkotoki, 2nd week of February? Okay, do say, tell us, fixed on 8th of February. 8th. Thursday.
If your lordship permits me, my lord, I have some urgent personal work at 2, my lord. My lord, may I pray this matter may be taken up tomorrow or day after?
Today now? How long will you take? It's not even finished by 12 o'clock. And if you cannot complete, we'll spill it over. Don't worry. But we'll complete it today itself. Don't worry. Yes. Your matter only. Yes. No, we have called your matter only. So no, I think 2 is 2. 2 is your matter. Yes, 2.
My lord, this application is against an award, my lord, passed by Labor Court. My lord, this is a case of disproportionate punishment. So I will take your lordship to charge sheet, my lord. That is annexure 1, page 9. It has come to the notice of the management that
Page.
page 9.
It was a 2A reference or section 10
Section 10,
by the union.
by the
Okay. Page 9.
page 9, that is the
Okay.
charge sheet.
Your name is, the workman is Safaudin.
Shafauddin Ali.
Okay.
It is 19 July, 2001.
Right.
It has come to the notice of management that you have not deposited the foodstuff, ration money collected from the workers of the below cited period to the Khomtai main office, which is contrary to the standing practice of the guardian. On top of this, it is also noted that in the return submitted by you to the store, you have deliberately given false salam number, etc., showing that the money of every fortnight was deposited to the head clerk, which also otherwise clearly transpires as to your ulterior motive and malified intention. Then my lord, statement has been given, my lord, and it says the proof is an offense under standing order enforced in the case. And it also says, my lord, it will worth mentioning to note that in earlier occasion of similar financial anomaly were detected, which you were when you were at Batikwa division as Man Mohra. At the time, the management, in response to your apology as well as undertaking to lenient you and strictly warned you by this office letter to ensure. This is the allegation, my lord. And I submitted reply, that is page 11, annexure 2. Respected and humble, I beg to heartily request you that kindly consider me for last time for the following offense, which was happened by me from a few days ago. I have not submitting the ration money from April 2001 onward. I know, sir, it is a major offense, but I have expend this money on my marriage ceremony. I heartily request you that I will be submitting the following money within a week, and kindly not suspend me from the duty. Otherwise, my family and my wife will face big problem to solve the economic side. I promise next time, and this is the reply submitted by us. And therefore, my lord, fight annexure 3, Thursday was issued. And I will submit it. Therefore, I will take your lawsuit to the award.
Okay. Now, where is the termination? Termination order 7-1,
Termination 7,
page 12.
page 12. Page 12, annexure.
Okay.
Further to the letter reference number so and so, and impartial domestic inquiry in conformity with the principle of ministerial justice and fair play was held on 22/9/2001, where you were given full opportunity to defend yourself by cross-examining the witness. I have studied your case carefully and have gone through your explanations, inquiry proceedings, and finding of the inquiry officer, and I have come to the conclusion that the charges leveled against you have been proved conclusively, and you have been found guilty of gross misconduct for fraud and misappropriation of company's money with malified intention of personal gain and breach of trust in your day-to-day duties. As stated in the letter, reference number so and so, a personal hearing was granted to you on 19/12/2001, and the statement given by you in the said hearing was, however, not found satisfactory. As you have been found guilty of gross misconduct, it has been decided that you should be dismissed from the service of the company. Further, I have gone through your past record and have not found any accentuating circumstances to take a lenient view in the. In fact, it has been found that on earlier occasion of similar offense, you were charge-sheeted and the management have excused you with a strict warning. Had charge-sheet dated 21 to 2000 on your written assurance that you will not indulge in any misconduct in future. Under the circumstances, you are hereby informed that you were dismissed from service of the company with effect from 10 January 2002. As you were found guilty and the charges leveled against you stands proved, you are not entitled to any difference of wages paid during the period of your suspension. That is the dismissal letter, my lord.
Okay.
And thereafter, we filed return statement, management filed their return statement and also additional return statement, my lord. Thereafter, the award was passed on 31/12/2010.
Page 14 is your written statement.
Yes. This 14.
And where is the written statement of management?
This is annexure 5,
At page 17.
page 17. 17 is additional, my lord.
No, 17 is not.
Additional return statement filed by management.
No, 17 is written statement.
Return statement.
Okay.
Annexure 4, our return statement.
Yes.
I will take a lordship to our return statement.
Come to the award.
Award.
21 addition.
That is page 23. I just also got.
Yes.
This reference was received from Government of Assam. Had notification number so and so for adjudication of the issue framed by it. The issues were as under. Whether the management of Kumtai Tea Estate, post office so and so is justified in dismissing the service of Mohammad Safiuddin Ali, office clerk with effect from 10/1/2002. If not, is the said workman entitled to reinstatement with full back wages or any other relief in lieu thereof? Upon receipt of the reference case number 1 of 2007 was registered there and notices were issued, both the sides asking time to file the return statement and the documents they intended to reply. Accordingly, the management side filed its WS and additional WS on 10/6/08 and 16/11/09 respectively, while the Sangha submitted its WS on 38/6/2008. The case of the management is as under. By virtue of charge sheet dated 19/7/2001, workman Safiuddin Ali was charged by the management with gross misconduct of fraud and dishonest, and by letter dated 23/7/01, the workman at his own free will admitted the charges. Being not satisfied with the reply, the management issued notice of inquiry dated 13/9/01 to the workman, informing him about the date, time of the proposed inquiry and the name of the independent inquiry officer appointed to conduct the inquiry. The inquiry was held on 22/9/01. And the inquiry officer conducted it in accordance with the principle of national justice. The workman was present at the inquiry and he was given full opportunity to defend himself. He was given opportunity to cross-examine the management witnesses and to examine his own witnesses. In the inquiry, the workman admitted the charge leveled against him. The finding of the inquiry held the workman guilty of the said charge. The management concurred with the finding of the inquiry, however, by letter dated 12/12/2001. The management gave opportunity of personal hearing to the work. In the personal hearing taking place on 19/12/2001, the workman again admitted the charges leveled against him. After taking the past record of the workman into consideration, the management found no extenuating circumstances to take a lenient, and so, by virtue of a letter dated 7/1/2000, the management dismissed the workman from his service in the larger interest of the maintaining discipline of the district. The case of the Sangha is under. The workman's office of Conducting Division of Kumtai District did not deposit the ration money collected from the workers for the period from 3/2/2001 to 28/7/2001 in time. So he was suspended by the management and charge sheet dated 19/7/2001 was issued to him. Afterwards, by letter dated 10/1/2002, the management dismissed the workman from service. Though the workman deposited amount of rupees 10,000 in cash immediately on receipt of the search sheet and another amount of rupees 6,000 a few days later, and thereafter on the prayer of the workman to so recover and to excuse him for his lapses until this amount of rupees 6,000 was recovered from his suspension pay. His prayer for excusing him was not considered by the management before dismissing him from service. The suspension letter clearly shows that the then senior assistant manager and accountant not supervise the work of the garden regularly, and so he was also responsible for the lapse. The domestic inquiry proceeding and final report of the inquiry officer were not provided to the workman and for his defense, and so his dismissal was illegal. The fact that immediately after the suspension, the workman deposited the amount proved that he did not misappropriate the amount and he did not have such intention, but instead of giving him any chance of uh, of 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 rectify himself, and instead of imposing any lesser punishment on him, the management dismissed him from his service, which was unjustified, illegal, and prepared to decide the issue in favor of the workman and to instate him with full back wages. The management examined two witnesses in support of his plea. The Sangha examined none, and the workman refused to.
This. No, madam. No, bro. Or at least 20 minutes.
Both the learned counsel let me through WS and the evidence of both the sides and made submission argument in support of the respective various cases taken therein. Also peruse the case records, including the service record therein. Issue number 1. Let me first find out whether the domestic inquiry held by the management was a valid one. In his WS, the management claimed that domestic inquiry was held according to the principle of national justice. In his evidence, MW1, Udhan Chandra, the inquiry officer says that on being appointed by the management with his consent to conduct the domestic inquiry of this case, he asked the management to fix a date for inquiry and to issue notice of inquiry to the workman. And he went to Humtai State on the dates of fixed to conduct the inquiry. He claims that in addition to the workman himself, two independent observers, B.K. Sharma and Saifuddin Ahmed, were also all along present during the whole of the inquiry with the consent of the workman. He affirms that after receiving all the relevant documents from the management, he did offer the charges to the workman, and the workman admitted his guilt. But in spite of that, he proceeded with the inquiry. He proved Exhibit A as the search sheet and Exhibit B as the reply of the workman, whereto he claims that at first he recorded the evidence of the management by calling them one by one, and then he recorded the statement of work. He proved that Exhibit C as the proceeding of inquiry, Exhibit C as the signature thereof, Exhibit C1 as the signature of the workman, Exhibit C3 and Exhibit C4 as signature of the independent observer. Accordingly to him, after completion of the inquiry, he submitted Exhibit D, that is the finding of inquiry. MW2 is Ramendranath Purva, the manager of Kumtai State. The relevant period, after relevant period, in his evidence, he entirely claims that firstly the workman is to work in Buttodikwa division of the tea state, and while serving there, once he was charged for his misappropriation, but he was dealt with leniently and was transferred to Hinderting division of the tea state when he was working at the relevant time after being warned. He says that after receiving the finding of the inquiry from the inquiry officer, he dismissed the workman from his service for his finding him guilty of the misconduct of misappropriation. He clearly says that as the workman was previously warned, he was not served with second so-called notice prior to being dismissed from service. The above claims of the management witness are not in dispute, though none of the management in evidence claims that the inquiry was held according to the principle of justice. Their evidence shows that except non-issuance of second so-called notice to the workman before dismissing the workman from his service, the inquiry was held according to the relevant procedure. Let us now consider the evidence of the Sangha before deciding whether thus non-issuance of second so-called notice to the workman adversely affected the validity of the inquiry. In his document, the Sangha has claimed that domestic inquiry proceeding and the final report of the inquiry officer were not provided to him for his defense. Does that adversely affect the validity of the domestic inquiry? It cannot be disputed that if in fact the documents were not furnished to the workman, it constitutes violation of procedural provision. In Amit Dewan versus Assam State Cooperative Marketing Consumer Federation and others, his lordship so our High Court held that procedural provisions are generally made for affording a reasonable and affordable opportunity to the delinquent officer. They are conceived in his interest. However, violation of any and every procedure cannot be said to be automatically vitiate the inquiry. The complaint of violation of procedural provision will have to be judged from the point of view of prejudice. Again, in Haryana Financial Corporation, Kailash Chandra, the Honorable Appeals Court held that it is for the delinquent employee to plead and prove that non-supply of a particular document has caused prejudice and resulted in discourage of the. In Surba Uttar Pradesh Gramin Bank, their Lordship Honorable Mr. So-and-so of the Apex Court held that where procedural requirements are not complied with, prejudice must be proved and not presumed. Thus, from the above decision, it is clear that violation of a procedural provision does not vitiate the domestic inquiry unless the delinquent pleads and proves that such violation has caused prejudice resulting in miscarriage of justice, and that prejudice must be proved and presumed. Now, when in the light of the above principle of law, the evidence on record is examined to find out whether the workman is able to discharge his burden of pleading and proving prejudice on account of non-supply of the above mentioned document. It is in that not only the workman has neither pleaded nor proved prejudice in this case, he also does not even specifically support the plea taken in the WS about the state document being not furnished to him in his evidence as the workman witness one. And it will establish that the workman did not suffer prejudice on that count. In view of the above, I find and hold that domestic inquiry cannot be held to be invalid on that ground. Now coming to the fact revealed from the evidence of MW2 Ramendranath Purva, the then manager of Kumtai Tea Estate, that as a previous incident of misconduct or misappropriation committed by the workman while working near Kutuli for prevision of the tea estate, the management treated his case leniently and let him after warning, no second focus notice was issued to him in the case. After receiving the finding of inquiry officer and before dismissing him from his service, it is seen that not only the workman, he neither pleaded nor proved prejudice on that count, as also does not mention that allegation in the WS or his defense. So I find and hold that workman did not suffer prejudice on that count alone. Hence, in my considered view, the domestic inquiry cannot be held to be invalid or on the ground also. In view of the above discussion, I find and hold that domestic inquiry conducted by the management was fair. Now, MW1, inquiry officer proves Exhibit A as a charge sheet issued by the management to the work. On perusal, it appears that workman did not deposit the sum amounting to rupees 20,514.78 collected from the workers to the main office of Kumtai. In other words, he was charged with the misconduct of misappropriation. It was a serious misconduct and was proved in the domestic inquiry. Now, in UP State Road Transport Corporation, Mohanlal Gupta and their Lordship Honorable so of the Apex Court held that misappropriation being a serious offense, the court cannot exercise its discretion and alter the punishment dismissal from service. In view of the above, I am of the considered opinion that punishment of dismissal from service imposed by the management of the workman is not liable to be interfered with by this. Hence, I find that holder management of Kumtai is justified in dismissing the workman conscience. And issue number 2, in view of the above decision arrived at, in respect of issue number 1, I find and held that workman is entitled to the statement full purpose or very clear. So this is the award, and against the award, my lord, I am before your lordship.
Yes.
My main point of argument is that, my lord, this is a case of, my lord, this is a case of, my lord, not a case of misappropriation, my lord. And first punishment has been imposed on him, my lord. And my lord, the amount he has my lord, returned back the amount, my lord. There is no not non the amount is not misappropriated. And he collected the respond money from the workers for the period from 28/3/2001 up to 3rd July 3/7/2001. He did not collected the money, he did not deposit the money, but immediately after charge sheet and when he was suspended, he entire amount he deposited. There is no misappropriation. So harsh punishment, harsh capital punishment, my lord.
Misappropriation is is it required to be permanent in nature?
It is not.
Will return of the amount totally obliterate the charge of misappropriation?
It is not.
And return when? After the charge sheet?
After
10,000 you have
after his suspended.
10,000 you have returned after receipt of the charge sheet on 19/7/2001
Yes.
and subsequently 6,000.
Another 6,000 deducted from his. And this is the offense. My submission before your lordship is.
What
that-
about your antecedents? On earlier occasions, there has been
Yes,
have
it
been
is,
instances.
and that is true. That is. So
No,
my
what
lord,
we are concerned is not with, though the amount is also not very material,
Yes.
whether it's 10,000 or 1 lakh, misappropriation, but we are on a different context. This amount is for ration for the laborers.
Yes.
How will the labor survive?
No, my lord. What happens, my lord? This system is that, my lord. It is the responsibility of the workman concerned, my lord, to issue a slip on
See,
taking
you
the
are
amount from the
see, you
labor,
are the clerk of the estate.
my lord.
You are the clerk of the
Yes,
estate.
yes.
The ration money has to be released by you, through you.
Yes, my lord.
You
He
said in
collected the
you said
respond
in
money.
your initial defense that there was a marriage ceremony in your house, so you had utilized the money there.
That is
That is not permissible.
that's
That is
true,
not
my-
permissible at all.
That's true, my lord.
And had it been from some other source, here you are dealing with the money of laborers' day-to-day living, survival.
Yes. My lord, what happens?
On the proportionality, what do you say? Proportionality? Is there any other punishment which could have been
Yes,
imposed
my lord.
upon you?
Another fact, I will take your lordship to that, my lord. Here, what happens, my lord? Immediately thereafter, my lord, the workman, my lord, he joined as state teacher in 2012.
As?
State teacher, my lord.
Hmm.
He, my lord, cleared the teacher eligibility test, my lord, and thereafter he joined as teacher and he's serving as that, my lord.
He is presently serving.
Yes.
So why do you
My
why do
lord,
you want to come back to the estate?
and that is why my submission before your lordship is that for that period, from his my lord termination till 2012, my since my lord there is punishment is capital punishment has been given, my lord.
Capital punishment.
Yes.
What is
Of-
capital
of-
punishment?
Of my lord,
What is the meaning of capital punishment?
harsh punishment, my lord, harsh
Har-
punishment.
Harsh punishment is a different connotation. Capital punishment
no,
has got a
no,
totally
no.
different
No,
connotation.
it's a harsh
Don't use
punishment. No,
expressions so loosely.
Today I told you what, my lord, is a harsh punishment has been inflicted upon him. So I submit, my lord.
No, for that period from 2010 to 2012,
May I
what you are
tell-
indicating that will come only when we hold that the dismissal is bad in law. If we are agreeing to the conclusion of the learned labor code, then that question will not come at all. First, you have to make out a case that the dismissal is bad.
My
And-
only submission is that, my lord. It does not.
Now,
promise-
Madam, see, there are two things. Let us be very clear. Even if you are able to make out a case that the dismissal is not sustainable, then reinstatement is not necessarily to be accompanied by another direction for back wages. That depends on all the factors. It may not be at all with back wages. It may be 10%, 25%. But first, there has to be an order of reinstatement. You have to overcome the first hurdle, that you have made out a case that the dismissal order is bad in law, not sustainable. And after overcoming that, then second is to satisfy the court that you are entitled to the back wages. Now, first hurdle, we find that you have got a lot of difficulties in overcoming.
That's true, my.
See, we can just thinking aloud, we can just put it to you so that you can respond. First, you have admitted the guilt. Number two, even in the written statement filed by your organization, filed by your association, in page 15, paragraph 3, you have made a categorical statement before the labor court that you have made payments after receipt of the charge sheet. That amounts to clear admission. Misappropriation was there. Number two, it's a recurring offense. There is no denial. Number three, the charge is grave. It is not only charge of misappropriation, this is a charge which relates to the ration money of the laborers. And apart from raising questions on your integrity, the hardships to the laborers will be a very relevant factor. On this issue, if you can address the court, it's good. Otherwise, we are not so much inclined.
Today, may I pay for time, my lord?
Time is the last thing we'll be granting today. These are all matters. We have
Put the
to.
facts in background, my lord, because with this facts in background, my lord, because the workman admitted his guilt. There is no, I cannot.
You have not stated, you have not advanced any arguments on the defense you have raised before the labor court that the report of the inquiry was not given to you. What do you say on that? Labor court has said something regarding that.
There is no submission, on that point, there is no submission before labor. Right.
No, labor court has made a categorical finding. It has come to a finding that labor court has relied upon a judgment of the Honorable Supreme Court.
Yes.
And has stated unless you plead prejudice, it is not required. Do you have anything to add on that? You come to page 27, I think. No, not 27.
28, 29.
Yes, page 28, first paragraph. Sarva Uttar, Gramin Bank. Where procedural requirements are not common. No. Yes, prejudice must be proved and not presumed. Okay, any decisions you'd like to rely upon, madam?
My lord, I will, my lord, Firestone case, my lord.
On the fairness of the domestic
Fair,
inquiry.
fine, fair.
That is already been raised.
Firestone, on the Firestone case, my lord, and
Firestone and Ludbur Singh.
Firestone case, and another decision I will take to the 2015, 2 SCC 410. That is also, that collector LML limited.
This LML.
Paragraph-
LML, which paragraph?
Paragraph 5 and 8, sir.
Five and 8.
5 and 8.
Collectors. Madam, in this collector Singh case, the award was in favor of the workman.
Yes,
The management had approached the High Court and said that under 11A, the powers exercised was not done in a judicious manner. That was the contention. That was rejected by the Honorable Supreme Court. Perhaps this 11A we are not is not the subject matter. Firestone, which paragraph?
paragraph 10.
10.
No, collector Singh case, my lord.
No,
paragraph-
collector we have read 5 and 8.
and Paragraph 10 is also there.
10.
It is incorporated in the scheme of contention that the hands of planet quantum of punishment.
Then will not help you. This LML case, collector Singh case, revolves on the, around the power under section 11A,
11.
the power to modify by the learned labor court. What? Which paragraph in Firestone?
Firestone paragraph 34.
34.
Paragraph 32 and thereafter 34. Firstly, my lord, paragraph 32, subparagraph 9.
Okay.
Once the misconduct is true, at the inquiry conducted by an employer or by evidence to superior tribunal for the consent. The punishment imposed cannot be interfered by the tribunal if this is the punishment is so hard as to suggest victimization.
Hmm. It is qualified. It has to suggest victimization. The order of
The
punishment.
punishment is so as to suggest victimization. And here, my lord,
And 34? 34 is again 11A.
yes, this will be a convenience is to consider the content of section 11A. To invoke 11A, it is necessary that an industrial dispute of the type mentioned there should have been referred to an industrial specification. The case of adjudication, the tribunal has to be satisfied that the order of discharge or dismissal was not justified. If it comes to such a conclusion, the tribunal has to set aside the order and direct reinstatement of the workman on such term as things state. The tribunal has also power to give in under relief to the workman within the imposing of lesser punishment, having due regard to the circumstance. The proviso casts a duty on tribunal to rely only on the material record and prohibit it from taking any place evidence. Even a mere reading of this section in our opinion does not indicate that a change in the law as laid down by the court has been effected. According to the workman, the entire law has been completed out, but it is according to the employee, a very minor change has been affected, giving power to prove. This is according to the employer, the tribunal has a mere power to alter the punishment. After it proves that the punishment is discontinued, the workman on the other hand claims that law has been rewritten. We cannot accept the extreme contention advanced on behalf of the workman and the employee. We are aware that the act is a beneficial piece of legislation enacted in the interest of employee. It is well settled that to constitute the provision of a welfare legislation, courts should adopt which is described as a beneficial route of construction. If two constructions are reasonably possible to be placed under a section, it follows that the construction which furthers the policy and object of the act and is more beneficial to the employee has to be preferred.
Okay.
So my submission before Lordship is that, my lord. It is no doubt, my lord, workman admitted his guilt. And on immediately thereafter, my lord, he realizing he refund the amount. And therefore, my respectful submission to your lordship is that, my lord, your lordship will, my lord, for that year, some benefit may be given, my lord, like your lordship will dispose of the petition with a direction to pay the workman whatever legally entitled to him. With that direction, your lordship may dispose of the petition. If he is entitled legally, that may be directed to be paid.
From 2012, you are still in a TET, as a TET teacher.
Yes.
No allegation of misappropriation.
No, nothing, my lord. He is very, very honestly, he is serving, my
You have reformed.
yes, from this accident. And therefore, my prayer is that, my lord, for
Okay.
that period, some relief may be granted, whatever is legally entitled by him.
I
With that-
consider. Yes, yes. Yes, we'll hear it. What is your name?
50,000.
Vedas. You're not on record.
Lordship, not
You're for the management.
Lordship, I'm for the respondent of management.
Okay, okay, tell, yes, please
Lordship,
submit.
The only issue, Lordship, here is that whether the punishment imposed is proportionate to the gravity of the offense. In such circumstances, Lordship, I'd like to place two judgments of Supreme Court.
Yes,
He will pay.
2006. 12
Lordship would kindly
SCC.
take, 12 and 55 September. In this case, Lordship, the Supreme Court has held, Lordship, in cases where there is person is found guilty of breach of trust, Lordship, the removal of
Which paragraph?
Lordship, paragraph 7 is the relief.
7.
Sir.
Just a minute.
May I read?
Just a minute. Please read.
We have heard learned counsel appearing for the appellate management and peruse the record. In our opinion, the order passed by the High Court is erroneous on the face of the record. The High Court, in our opinion, ought to have seen that the misconduct was duly established in the inquiry, and despite it, the Labour Court had persuaded itself to reinstate the delinquent in service. The learned single judge also confirmed the order passed by the Labour. In our opinion, the High Court was not justified in offering the quantum of punishment when the inquiry was held to be fair and proper. Charge was proved and no evidence was led before the Labour Court while questioning the order of the disciplinary authority to the delinquent work. Likewise, the High Court also failed to notice the order including the name of the respondents from so. The High Court also urged taking note of the fact that the punishment imposed on the delinquent official was not shockingly disproportionate to the gravity of the misconduct against him, coupled with his history and he being a guilty convict. In this case also, this was the second instance. In our opinion, the division bench has erred in rejecting the plea of the management that the Labour Court was not justified in ordering the instatement of the respondent as regular employee on the ground that such a plea was not raised for the judge, when, as a matter of fact, the plea had been taken both for the Labour Court and the management of the. Question also comes to paragraph 9.
9.
9.
Yes.
In the instant case, the position held by the employee is one of faith and trust. The conductor holds the post of trust. The person guilty of breach of trust should be imposed punishment of dismissal from trust. The respondent's conduct in not collecting the request fare at the designated place from persons who had traveled were in violation of the various regulations contained in the provisions. So in this case, it was held that the punishment of removal was not disproportionate. That is the second judgment, Lordship, 2010, 555.
Just a minute. Okay, next case,
Student 10, 6, 5.
UP Road.
UP Road Transport. But in this case, the Supreme Court held that no punishment.
Which were paragraph?
Paragraph 23 and 24.
Twenty-three.
23.
Yes, please read.
It went so this court held that the punishment should always be proportionate to the gravity of the mis- However, in a case of corruption, misappropriation, the only punishment is thus in view of the above, the contention raised on behalf of the employee that punishment of dismissal from service was disproportionate to the proved delinquency of the employee, not for excess.
2010. Solo pesado, como solo pesado. Itu related. Itu Mohan, itu beleg nahi. What is this 2000?
This worship, the court
Uh,
was dealing with the issue when the pre-instatement was not justified.
2009 SCC.
2009 SCC 520.
Okay, this is also you are relying upon.
Paragraph 6, 7 and
2009 or 2000. Paragraph?
6, 7 and 8. The learned advocate appearing in support of the appeal deeply contended on two counts. On the first, it has been satisfactorily contended as to whether the labor court can alter the punishment awarded to the workman upon recording a finding that the charges have duty been proved. And second, it has been contended as to whether the employee who has admittedly misappropriated the property of the employer can be allowed to retain in service. These two issues are undoubtedly of some importance. The workman concerned during the course of inquiry in no uncertain terms admitted his guilt, so however has stated that the same amounted to mere negligence and not a deliberate. But the labor court, being the fact-finding court, came to the conclusion that the charges could prove and we are not in a position to reassess the factual situation at this stage of the proceedings under Article 6 of the Constitution. The finding as regards the proof of charges shall have to be taken as accepted and do not see any perversity therein having regard to the state of fact, more so by reason of acceptance of charge by the delinquent. In the wake of the situation as above, we are of the opinion that the question of award or any minor punishment in the facts of the matter under consideration does not and cannot arise, and neither the labor courts could alter the punishment of termination of service, having regard to its assessment of facts and the contentions as regards the validity of the inquiry proceedings. The employee has been found to be guilty of misappropriation, and in such an event, if the appellant corporation expresses its confidence vis-a-vis the employee, it will neither be proper nor fair on the part of the court to substitute the findings and confidence of the employer with that of its own by allowing reinstatement. The misconduct and proof in such situation by reason of the gravity of the offense, the labor court cannot accept and alter the.
Okay. Okay. Yes, any reply? ফেরি করে নাকি ব্রেক টু লেভেলে যে যাও নাকি We'll pass the order. We'll take a break and pass the order. The legality and validity of an award dated 31/12/2010 passed by the learned Labour Court of Assam at Dibrugarh in reference case number 1 of 2007 is the subject matter of this writ petition. Full stop. By the impugned award, comma, the dismissal order dated 7/1/2002 in respect of the workmen concerned has been upheld. Full stop. Para. Before going into the issue which has arisen for determination, comma, it would be convenient if the facts of the case is narrated in brief. Full stop. Para. The petitioner workman Muhammad Safauddin Ali was working as an office clerk in the Kumtai Tea Estate. That is the response number 1. Full stop. On 19/7/2001, a charge memo was issued to the said respondent, which pertains to non-deposit of food stuff, food within bracket ration money to the laborers. Full stop. The details of the period and the amount involved have also been given in the said charge memo. Full stop. And it has also been reflected that there have been earlier instances of similar nature, and accordingly, the workman was directed to submit his response, full stop. The said order, by the said order, comma, the workman was also placed under suspension, full stop, para. The aforesaid charge memo was replied to by the workman on 23/7/2001, full stop. In the said reply, comma, the workman has admitted his guilt of not depositing the amount, full stop. He has, however, prayed for condoning his default and has cited certain personal reasons for utilizing the money for such purpose, full stop. The matter was inquired into and vide the order dated 7/1/2002, comma, the workman was dismissed from service, full stop. The termination order, the dismissal order clearly reflects that there was a domestic inquiry, and there has been earlier instance which was also documented in form of communication dated 21/2/2000, full stop. The aforesaid order of dismissal was raised on behalf of the workmen by the union by way of reference before the learned Labor Code of Assam at Dibrugarh, and accordingly, the aforesaid reference case number so and so was registered, full stop. The both the Sangha, I go to union, believe sir, raised by the union, raised by Sangha, SNGHA, S to capital, and the management had filed written statement, full stop. The management had also filed additional written statement, full stop. The learned labor court, after initiation of the proceedings, had recorded the evidence of the workmen and two numbers of management witnesses, namely one Bodhen Chandra Bora and one Ramendranath Borua, full stop. After discussion of the materials, comma, the learned labor court had passed the award dated 31/12/2010, whereby the order of dismissal has been upheld, full stop. As indicated above, comma, it is the legality and correctness of the order which have been questioned by way of this writ petition, full stop. Para. I have heard MSA Bhattacharya, learned counsel for the petitioner, whereas the management is represented by Sri P. Das, learned counsel, full stop. The LCR which have been transmitted to this court have also been carefully perused, full stop. Para. MS Bhattacharya, the learned counsel, has made the following submissions. Small one. the charge is not of misappropriation, as has been, and the expression of misappropriation has been inappropriately used. Full stop. Number two, the amount in question have been returned back, and therefore there cannot arise any case of misappropriation at all. Number three, the penalty of dismissal is not only harsh but disproportionate vis-a-vis the nature of the charge against the petitioner. Full stop. Para. The learned counsel for the petitioner has submitted that the amount in question having been returned, comma, there was no occasion for taking a decision of imposing the severe penalty of dismissal. And this aspect of the matter was not taken into consideration by the learned labor court. Full stop. The provisions of section 11 capital A of the Industrial Tribunals Act, agote kolo niki act boli Act, 1947 within bracket hereinafter Act has also been referred to, which gives jurisdiction and power to the Labor Court oblique Industrial Tribunal to make necessary change oblique amendments in the penalty in an appropriate case. Full stop. Para. The learned counsel has, however, clarified that after that long after the order of dismissal, comma, the petitioner has now been engaged as a TET teacher, and therefore she would not pray for any reinstatement. Full stop. Full stop. She, however, submits that if the dismissal order is interfered with, comma, appropriate orders for payment of back wages may be passed in accordance with law. Full stop. Paragraph. In support of her submission, comma, MS Bhattacharya, the learned counsel, relies upon the following case laws. Number one, workman of Firestone, ... reported in 1973, 1 SCC 813. Number two, Collector Singh versus LML ... reported in 2015, 2 SCC 410. Full stop. Para. In the landmark case of Firestone, comma, the Honorable Supreme Court has held as follows. Quote Kuridim. Para. In the case of Collector Singh, comma, the following has been laid down. Full stop. Para. Ms. Bhattacharya, learned counsel accordingly submits that appropriate relief be granted to the petitioner by setting aside the award of the Learned Labor Code and also interfering with the order of penalty of dismissal. Full stop. Para. Per contra, comma, Sri P. Das, learned counsel for the respondent number one management, has submitted that the charge against the petitioner are serious and grave. Full stop. He submits that the records of the proceedings would clearly show that the petitioner has admitted his guilt. Full stop. It is further submitted that offenses of similar nature were earlier committed by the petitioner, which were condoned. Full stop. Para. No, para. He accordingly submits that. No, para. Sri Das further submits that the domestic inquiry was itself conducted by following the principles of natural justice, and the fairness of the domestic inquiry itself was upheld by the learned labor court. Full stop. He also submits that the charge was duly proved in the learned labor court by two numbers of MWs, and the proceeding and the procedure adopted by the learned labor court has not been questioned in this writ petition. Full stop. He accordingly submits that no case for interference is made out, and accordingly the writ petition be dismissed. Full stop. Para. The learned counsel for the management has referred the following decisions in support of his argument. Number 1, K. Murthy ... reported in 2006, 12 SCC 570. Number 2, UP State Road Transport ... reported in 2010, 6 SCC 55, and last number 2, 2000, it was UP State Road Transport ... reported in 2000, 9 SCC 521. It was chronology করে দিবা দে টু full stop. Para. The aforesaid cases mainly relates to the charge of misappropriation, which the Honorable Supreme Court in no uncertain terms have held such misconduct to be grave in nature. Full stop. In the case of ... it has further been held that in cases of misconduct, the penalty of dismissal is appropriate. Full stop. Para. The rival contentions made by the learned counsel have been duly considered, and the materials placed before this court have been duly examined. Full stop. Para. The writ petition has not raised any issues with regard to the procedure adopted either in the domestic inquiry or before the learned labor court. Full stop. The emphasis is mainly on the proportionality of the penalty imposed vis-a-vis the charges. Full stop. Para. To appreciate the contentions raised on behalf of the petitioner, it would be necessary to understand the nature of the charges and the response of the workman. Full stop. The charge memo dated 19/7/2001 clearly reflects the charge of not depositing the ration money and the details, including the period in question, have been clearly reflected in the said charge memo. Full stop. The memo also mentions that on an earlier occasion, a charge sheet was issued on 21/2/2001 on similar allegations, which was leniently viewed and was closed with a warning to the petitioner. Full stop. What is more intriguing is the reply of the petitioner dated 23/7/2001. Full stop. In the said reply, the petitioner has clearly admitted the charges of not depositing the amount in question and has only prayed for condonation of his default/misconduct. Full stop. The order of dismissal dated 7/1/2002 is preceded by a domestic inquiry, wherein the earlier instance have also been taken into consideration with reference to the charge sheet dated 21/2/2001. Full stop. This court has also noted that such admission was not only confined in the domestic inquiry, but even in the written statement filed by the workman, there is a clear admission of the charge, full stop. For ready reference, the averments made in paragraph 3 of the written statement dated 10/6/2008 is expected herein below, page 15, paragraph 3. Full stop. The workman has clearly admitted that rupees 10,000 was paid in cash immediately on receipt of the charge sheet dated 19/7/2001 and subsequently deposited rupees 6,000. Full stop. He has also admitted that the balance of rupees 6,000 has been recovered from his pay. Full stop. This court it has been contended on behalf of the petitioner that the penalty of dismissal is harsh and the charge is not of misappropriation. Full stop. This court is, however, unable to accept the said submission, as misappropriation is not necessary to be of permanent nature, and the mere fact of depositing the amount, that too after receipt of the charge sheet, will not obliterate the charge of misappropriation. Full stop. with regard to the proportionality of the penalty, comma, this court takes into account the following factors. Number one, there is a clear admission of the misconduct by the petitioner, not only at the stage of domestic inquiry, but also in the written statement filed in the learned labor court. Number two, the fact that the misconduct was repeated has not been denied by the petitioner. Full stop. Number three, the charge, the misconduct, though would seem to be of misappropriation, cannot be confined only to that, as the same is concerning ration money, which is meant for the laborers of the tea estate. Full stop. Therefore, number four, next. Apart from the issue of integrity of the petitioner to remain in service with the management, comma, the hardships caused to the laborers would also be an equally important factor, if not more. Full stop. Para. In the cases relied upon on behalf of the petitioner, comma, no, in the cases relied upon on behalf of the petitioner is mainly on the powers and jurisdiction of a labor code under section 11A of the Act. Full stop. In the instant case, comma, this court is of the opinion that the conclusion reached by the learned labor court is based on relevant factors and considerations, and the labor court being a court on facts, comma, this court would be loath to interfere with the conclusion unless such conclusion is perverse or based on no evidence. Full stop. In the case of K. Murthy, relied upon by the management, comma, the Honorable Supreme Court has also taken into consideration the history of previous misconduct, which is also applicable in the present case. Para. The contention has been raised on behalf of the petitioner that even if reinstatement is not, that in view of the present engagement of the petitioner, comma, reinstatement may not be prayed for, and appropriate orders be passed for back wages. Full stop. This court is, however, of the opinion that unless the order of dismissal, which has been upheld by the learned labor court, is interfered with, comma, the subsequent directions, and there will be no occasion to issue any subsequent directions. Full stop. In any case, comma, mere interference with an order of dismissal of the removal would not automatically lead to payment of the back wages, and it would all depend on the facts and circumstances of a particular case. Full stop. Para. In view of the aforesaid facts and circumstances and the discussions made, comma, this court is of the opinion that no case for interference is made out, and accordingly, the writ petition is dismissed.
Then may I pray, my
The
lord?
records may be set forth.
May I pray for observation, my lord, that the gratuity and other benefit if he's entitled to that may be.
That was not a part of the reference. So how can we say anything? We cannot go beyond the terms of the reference. If you are having any issue, you can come up.
Like,
I'm aware.
Okay, the LCR, be sent back forthwith.
I made a mistake in the morning, my lord. I'm told by the registry that it's a matter pertains to the bench 5. So, my lord, may I pray if lordship pleases to take up, my lord, now?
How can we take up? We're bench 4.
I know, my lord.
Make a mention tomorrow before the appropriate bench. We had granted you permission.
Right, my lord. That's my mistake. I apologize for this, my lord.
Yes, next.
Initially, it was all bench 4 matters, so new partitions.
No,
my
we
lord,
had asked you, does it
I
pertain to this
understand.
bench? You said yes.
My lord, the new
Make a mention
partition.
tomorrow. Before the appropriate bench. Okay, next.
Item 4 and 5.
May I please, your lordship? Item 4, my lord.
Yes.
4 and 5, there was claim for transport subsidy. That amount has been paid and it was.
4 is
time before
WPC,
net
4
fee.
is WPC,
4898.
489, we'll take up first or what? Which matter will take up first?
It can be disposed of, it can be, my lord, on paragraph order only.
Okay.
Because
Four.
already money is paid by.
4898. 4898.
Yes. Net fee, the money is lying with net fee and he was talking about the tax. Tax I have paid, my lord.
But they are just
57 lakhs.
because of that, that an amount
Over
of
there.
6 lakhs that hasn't been disbursed.
Yes.
Now,
The
what is
tax-
your
tax, my
instruction?
lord,
Your Honor,
57 lakhs.
Your
All
Honor,
tax is paid and my lord, now GST.
Then
is
you
not
verify and
applicable.
make the payment.
Yes,
You verify.
it is my lord there. My lord, all tax received. So
See,
there
we
is
are-
no money.
This
there.
is relying upon certain documents. We do not have the expertise to
yes,
express our views on the validity or correctness of the documents.
Issued by the tax
It's for the
department.
primary authorities. You verify and go ahead.
Your lordship can
in
get.
fact,
both
Lordship,
from
this matter was apprised to the DIPP regarding the use of the sale
a
fee.
complicated.
Okay.
They apprised us that we need to
Tax receipt.
apprise the honorable court regarding the procedure to be followed while disbursing the subsidy amount. And anyhow, Lordship, subject to Lordship observation, if Lordship direct, we will-
You consider and you make
Yes.
pass appropriate
It may
orders.
be
Okay.
part of the record, my lord.
Yes,
And
yes,
copy
sir.
may be, yes.
Yes.
Issued by the.
You just tell us the basic thing.
Tell all the. Money receipt, my lord, but
What was the issue?
tax. Here, my lord, that matters relates to the, my lord, transport subsidy.
This is
payment of transport subsidy.
4898.
98, yes.
4898 of 13.
4898.
Transport subsidy.
Transport subsidy, my lord, yes. One part was left that during pendency of the writ petition, they have released the amount to Netflix for disbursement. And Netflix was holding it, stating that, my lord, the tax department has submitted some demand.
Okay, yes, we remember. Yes.
So,
Now,
my lord, in the year 2013 itself, my lord, they have paid the entire. And now there is.
you
no
net
GST
you
is
verify
applicable.
whether it's been paid and you may take as action
in fact, Your Honor,
Okay,
an
sir.
amount of 9 lakhs 23,030 that has already been paid, Your Honor. Only an amount of 6 lakhs that was still to be paid. Your
Whatever
Honor.
paid.
No, what madam is saying that your objections that some dues were there with the tax department. She is saying that she has cleared the dues. You just get to verify whether the amount has been paid and you take appropriate action. If it's paid, then release the amount.
Lordship,
Second lakh.
Hard,
69 lakhs they have paid.
hard. MS and Saikya, learned counsel for the petitioner. Also heard Sri A. Kolita, learned standing counsel, Industries and Commerce Department, whereas Sri G. Das is present for the net fee. Full stop. Para. The matter pertains to a claim for transport subsidy. Full stop para. This court has, however, been apprised by the learned counsel for the petitioner that during the pendency of this writ petition, comma, an amount of rupees,
6,98,000,
No, no, 9
no, 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 the entire amount,
9 lakh.
no, the entire amount which was released to net fee.
That was 6,98,000.
Your Honor, total subsidy approved by the state level committee was 15 lakhs, 70. Lordship may kindly peruse page 12.
Tell us the amount we're writing, 15? 15 lakhs?
Your Honor, I'm just getting the figure correctly, Lordship.
As I know, it is 6,98,000.
Okay, 15 lakhs. 15 lakhs, 7,973,
15,07,973.
97.
Okay, this was the amount released to you.
Amount that was approved by the state level committee, against which, Your Honor, DIPP has released an amount of 9 lakhs 23,021.
9 lakhs, 20,
23,021
0 to 1, released by
by the DIPP, and that amount has already been paid, Your Honor.
DIPP means
Department of Industrial Policy and Promotion, Government of India.
Industrial Policy and Promotion.
Yeah.
This is the Government of India.
Government of India.
This has been paid to them.
That has been already.
Now, balance was how much?
Balance was, Your Honor, 6,47,952.
9,552. This, you had said that there is some due with the tax department.
Yes, tax
Now,
department
madam is
due.
saying that there has also been cleared.
Lordship,
Okay. Hold. কি করলো last ওখানে? Our rupees 15,07,973 was approved, which was approved by the state level committee, has been deposited to the net fee. Full stop. Subsequently, comma, out of the aforesaid amount, comma, rupees 9,23,021 has been released to the petitioner by the Department of Industrial Policy and Promotion, comma, Government of India. Full stop. This court has also been apprised that so far as the balance of rupees 6,47,952 is concerned, comma, due to certain dues with the tax department, comma, that was held back. That has been held back. Full stop, para. MS Saikya, the learned counsel for the petitioner, has, however, submitted that the said dues have also been cleared, and in this regard, she has placed on record certain documents to show the in support of the said plea. Full stop. Para. In view of the above, three full stop, para. Both Sri Kolita and Sri Das, the learned counsel for the respondents, however, are unaware. You are not aware? You are not aware of this?
No, I am not.
Are not having concrete instructions. Will not say unaware. Will say not having. No, yes, no.
This is a letter written itself for.
That is what. That is.
And these are only.
No, we are not directing you to pay. We are directing you to examine and take
Correct,
action.
correct. So
Do
they
not
have
have
to examine
do not have current concrete instructions in this regard. Full stop, para. In view of the above, comma, this court is of the opinion that the writ petition can be disposed of by directing, and then by making the following directions. Full stop. The petitioner may submit copies of the supporting documents with regard to the plea of clearing the dues of the taxation department to the appropriate authorities within a period of 15 days, madam?
Yes.
So 15 days. 15 days from today.
Yes.
And upon such receipt, comma, the fact, the matter may be examined and thereafter appropriate steps be taken for release of the balance amount in question, full stop. The appropriate authority is also required to pass a speaking order.
Lordship, these documents, sir, Lordship, these are only demand notice. Lordship,
But that,
kindly
against
produce these
that, my lord,
documents.
it
We
is
are not
online
asking you to
payment.
pay, you are asking you to examine and pass appropriate orders.
Confirm kora.
No, that's correct, Lordship, but this is only, I mean, she is not submitting any document of payment.
That
See,
is my
please
lord,
simply
online
stating-
payment, 56 lakhs, they have paid.
See, Lordship may kindly produce this 2013 letter. And these certificates are only certificates of demand.
But can you,
And
can
2011
you
document,
verify from the department?
that's.
No, no,
we-
madam,
online-
can you give the,
Online.
no, can you give the date of payment?
Yes.
Date of payment.
Yes, or date or any
Yes,
document
after-
of payment.
Any kind of.
I think Mr. Kolta is correct.
I'll inform it.
We
I'll
thought that
call
these
the
are
account.
documents of payment, these are only
These are
demand.
demand,
That's what they have.
Now, this order we can maintain, but you just
Exactly.
give in, place on
That-
record
yes,
some document.
yes.
I don't put piece of eligible. We'll take it up at after 2 o'clock.
Only to they have to fix that one. For the second issue. For inspection.
Now, even if you give us the date,
Yes,
the
because
details
they
of the
are-
payments,
nowadays
then also
all-
we can record it and place it to them.
all payments are made
But
by,
I'm pointing out also these documents doesn't show that like.
Yes,
the
yes,
company
you're
is-
correct, you're correct.
They
Yeah,
change
that's
it.
it. Yeah, that's it, all. And the other one, other
other
matter?
one, yes, my lord, that
Other
will
one
take
was-
some time, my lord. It is, my lord, that relating to, my lord, issue of eligibility certificate.
Okay, we'll start at 2 o'clock.
Yes,
I have to pay the case. Mr. Chaudhary, for which matter?
This one matter, my lord, item number 13.
Okay. For final disposal.
If my understanding can wait, it can go to February, my lord.
Financial bit, my lord. There's a-
Okay, we'll try after this matter.
My lord.
Okay, maybe around say 2:30, maybe,
My lord,
or short matter class in night. 14 key. 14 is your matter.
Yes.
Mr. Nayak, this will also take some time or what? Are you fine?
No, I don't think so.
Can we do it right now? If you can, we can have it right now.
not take much time. I have prepared a note, my lord. Your lordship may kindly go through this note, my, I can detail.
You give a copy to Mr. Nayak, I think.
Yes, ma'am. I am giving. They are confusing regarding, my lord, that Dag number, pata number, that has been clarified. And map, I don't think. so.
This will clarify everything, Lord.
Now, what is your stand?
Lordship, so far as earlier status is concerned, Doug number 16, in my map, Lordship, it's a residential plot. But so far as possession is concerned, it is eco-sensitive zone, Lordship. Even at that point of time also, it was eco-sensitive.
No, that was your submission on the last occasion also.
That is what I'm.
In your trace map, you have indicated, I think.
Lordship, this is the.
This is the original.
original
I
map,
think.
Lordship.
Oh, that we remember.
Lordship,
The actual possession is on a eco-sensitive zone. The plot shown is on a residential zone.
Lordship, petitioner is saying Doug number
Residential.
16 and 162 are same. Now 162, earlier it was 16. Lordship, earlier also it was 16 is a different plot of land, Lordship. Not in possession of, in her possession of.
This is done fresh or
That I don't know, my lord, why he is.
why don't you
confusing.
do a physical verification?
Feasible verification done,
No,
but.
physical
but by-
verification.
Yes, my lord, the advocate should go because this GMC authority and
162
GMD
is-
authority, all of them, twice they have earlier also, now also they have visited. GMC also and GMD also.
No, no, why is this
Why they are
anomaly?
confusing? GMD is confusing, not GMC.
GMC status was given by GMD only, Lord. GMC asked for status as regard Doug number 16. We said Doug number 16 is a residential plot.
Let us understand. What is the contention of the petitioner?
Lordship, earlier she applied for a building permission and
Of a
hence
plot of land,
for a plot of land, Lordship.
which she has purchased.
Yeah. That
Plot
is
of
the
land was the number
16.
16,
dark 16.
yes.
Okay,
Accordingly, GMC asked for the status of that particular plot of land,
yes.
and we gave certificate that that is a residential plot.
Building permission sought for. GMC give,
GMDA,
give, the status.
Certificate.
that it is a residential plot.
GM
Subsequently, Lordship petitioner abandoned the entire thing, Lordship,
give
17, they have,
opinion. Residential area.
it was approved in meeting in 14, 2014.
You said that building permission could have been, can be given, it's a
it's a
residential.
residential.
So far 16 is concerned.
16
That
is
number is
16 is concerned, okay.
Now, Lordship, again matter came, she again took up the matter, appraised Lordship, and again the matter went to the GMD authority.
Oh,
And this time GMD said, so far as Dock number 162 is concerned, it is a eco-friendly zone.
now the DAG number has changed.
According to the petitioner and also according to the revenue
Revenue.
department, Dock number 16 and Dock number 162 is the same plot of land,
Same plot of,
DAG 16 has become,
162,
new DAG is
162.
162.
Yes.
162.
But so far as our map is concerned, Lordship, the, I mean, 162, which is present today, Lordship, earlier it was 26, not 60. That is the map is showing now. That is why I have placed the map. Earlier also, Lordship, at that point of time also, Dock number 26 was a eco-sensitive block.
Unnecessary matter is complicated, my lord, because I have purchased the land in 2005.
No, now, if we can determine
Yes.
whether 16 has become 162 or 26 become 162, that will, I think, end the
Yes.
solve the matter.
If if they say that not 16, it is not 16, it is 26. 20, her position is on 26.
No,
26, Lordship. Lordship is there from the map, Lord.
because all these issues, my
Because
lord,
26 and
Namzari
162 is the
certificate
same
also
plot of land.
16. Why the mandal will issue Namzari certificate without verification?
That
It is
map,
the
we have
16.
not prepared, Lordship. It's a survey of Assam map, Lord. It is not the
But
creation of the GMP.
Creating the, asking about the map, my lord, they are creating confusion whether my proposal land is same, and on the page 20, my lord, your lordship will see that it was typing mistake. Page 20 at serial number 8, it is recommended, and it is from the residential zone. 6 also there, but my lord, it is my lord, some typing mistake, but 8, my lord, see, zone residential, page 20. The committee has approved my proposal earlier. Page 20, serial number 8. Here, my lord.
Where is the details of the land here?
Details of land, my lord. And it was approved, my lord. That is, my lord, page 23. Proposed. Annexure 6, page 23.
Yes,
Boundary is also given, my lord.
23. Where is the DAG number?
That number, my lord. Will be in this. That number. Find it. But my lord, same that number, I have enclosed the patta also, my lord.
Where?
Enclosed the
Okay,
copy of the
we'll
Jama
come
Mandi.
back at 2 o'clock.
Yes, copy of the Jama Mandi.
Okay, we'll come back at 2 o'clock.
Yes. 2009. And the certificate issued by Chief Executive Officer, my lord, GMD, that is of 2011. Once the certificate issued,
Now, how do we resolve the issue? Tell us. You are saying something, he is saying something else.
Some, my lord, your lordship, constitutory advocates, my lord.
No,
they
no,
can
it's
go
not a
and speak.
question of going and inspecting the site.
Other is, my lord,
It is a question of comparing with the records.
yes.
Advocate can go and see, but advocate will not know whether it's DAG number 16 and 162 are matching, or 26 and 162 are matching?
But the
This is-
revenue authority has issued a certificate, my lord, on my application.
Yes,
16
madam, what do you say, Hadarika?
16 and 162 is same.
This is
what
more within
more I
your
can-
domain, whether only a very, very small issue is there, whether the new DUG 162 is connected with 16 or
Same.
is it connected to 26? If it is connected to 26, 26 is earlier in the eco-sensitive zone, so 162. When? Oh, recently,
Recently, see the
7/12.
stuff of-
You get this instruction, we'll pass a very pertinent order.
Yeah,
So
my
that,
lord.
so
Copy
that,
of the Jamabandi also reveals. my
by
lord.
which it will facilitate you to get the instructions, okay?
Yes, my lord, cannot be have to appear, my lord, because I am suffering for.
I know,
yes.
oh no, when
And
can you?
Jamabandi copy, if your lordship, I have enclosed the Jamabandi copy also, my lord.
You take into consideration all the documents, madam. Ask your officers. 1/8. Yes, yes. 1/8, 18, yes. Yes. This?
You may take the record also, my lord, from the GMC.
This was written by whom? Your department. GMC,
GMC.
you can produce it. No, you produce this if you are,
And my lord, may I
this will
request,
be in
my
your
lord,
custody.
may I request, my lord, that main file is the GMC, that file, otherwise
Okay.
all this online.
Okay,
You may
heard,
produce the
heard.
file also.
MS N Saikya appearing in person for the petitioner. Also heard. MS G Hazarika,
Residential zone আছে।
Land Standing Council, Revenue Department, and Sri P Nayak, Land Standing Council, GMC and GMD. Full stop. A short controversy is involved in this writ petition. Full stop. To put it briefly, comma, the petitioner claims to have purchased a plot of land covered by DAG number 16 of KP Pata number 8 of village number 2, Kharapara, under Muza Beltola, right?
Yes,
Full stop. Though building permission was sought for and the GMD on such permission, on such application, had also gave an opinion that the area is residential in nature, comma, the constructions were not proceeded with, full stop. Thereafter, a new application was made, and in the meantime, comma, according to the petitioner, there has been new numberings,
the number is
full
changed.
stop. No, according to petition, according to petition, according to petition, according to the petitioner, comma, the earlier DUG number 16 has now been numbered as 162.
Yes.
Full stop. The issue involved is the rejection, is the non-consideration of the building permission on the ground that DUG number 162 is in the eco-sensitive zone. Full
As
stop.
per map 2007.
Eco-friendly zone. Full stop. Para.
According to
Three.
map of
Okay.
2007 and 8.
So, the land, MSIK, the land, MSIK has also referred to numerous number of documents to support her claim. Full stop. Para. On the other hand, comma, Sri Nayak, the Learned Standing Council of GMCA/GMDA, has submitted that the new DUG number 162 is connected with the earlier DAG number 26, which is also 26, which was an eco-friendly zone, and therefore there is no change in the classification of the land. Full stop. Para. He has also raised an issue that the land under possession and the DAG numbers are not matching. Full stop. Para. The issue, however, can be resolved by a clarification from the revenue department. Full stop. Para. Ms. Hazarika, the Learned Standing Council has in fact placed on record, has in fact referred to a communication dated 7/12/2023, whereby কি করো last order? Three in this regard, full stop. She, however, prays for some more time to obtain instructions on the issue as referred above. Full stop. Para. As agreed to by the Learned Council, as agreed to by the parties, comma, list this case on. Tell us.
Tuesday, my lord, next is. Next is.
Today is what? 4th. We'll have it on 11th. Next Thursday. Next Thursday. On 11th. On which date, comma, necessary instructions may be obtained by the Learned Standing Council Revenue Department. Full stop. Para. Let a copy of this order be furnished to Ms. Hazarika, the Learned Standing Council Revenue Department, during the course of the day. But Mr. Nayak, have a look at this communication. Oh, no, read this letter.
I'm trying to find out. My location of DAG number 16 is same revenue department.
Revenue official, call my lord. Otherwise, my lord, how many dates, my lord? Because the map
I
was
think it should be resolved. It should be resolved. Don't worry.
7 and 8. At that time, 162 was eco-sensitive. And my lord, my DAG was 16 at that time. Now it has become 1.
Okay.
So I'm unnecessarily victimized, my lord.
Suggest that they are still in depth the sentence because
Has it been cleared or not?
that amount hasn't been cleared. This document is of fee.
No, wait.
At present, my lord, GST is not necessary because food items have been exempted. Huh?
But these items are, the amounts are not matching please.
different amount, my lord, by check number, different date.
Take some, take a receipt. Otherwise, some will only be utilized for paying the. Not like the
Disputed claim means because otherwise they would have eligibility certificate, they would not have paid it. But due to long pending of the case, they have paid it. Paid the amount as billed. Is that it?
No, here this item, the amounts involved are not matching at all, madam. They say that there is a balance of 647,952, which is the due to taxation department, and therefore it's not being released. You say you have paid this amount. Now, therefore, there is no hurdle in refunding. But
Yes.
your letter, which you have handed over of 2015, 16 to, this is of different amounts. 69 lakhs.
60 lakhs they have paid, I think, here by disputed amount is 60 lakhs. All this, I could not make it, my lord, 60 lakhs. Excess, no, my lord, that this, you have realized excess rupees 8,71,000 from net fee. This is another amount they have taken. No. You have wrongly done. Because I didn't get the eligibility certificate, so I have to pay. So I have to pay.
That's what I'm saying.
Just submit it.
I'm saying that like.
Now, Mr. Kolita, there is one thing. See, the amount approved by the SLC was 15 lakhs odd. Okay. If you want to contend that the liability towards taxation department is more than 15 lakhs, then why was 9 lakhs 23,000 released to the petitioner, number one? No, understood. If the sale tax demand has come or it came to the notice later on, why was it divided into two parts? Why 923 or 021 at the first go? Why not the entire part? No, that is what exactly we are asking. You say that you are saying that the balance of 647 has been retained because you have come to know that there are certain liabilities towards the tax department. Mr. Kolta is trying to say that, or has said that the liability towards the tax department is much more. Much more. Then if it's much more, the entire amount should have been retained. Why 15 lakhs? Out of 15, 9 was already released. No, that is what we are not understanding, Mr. Das. If out of 15 lakhs, you come to know that there is a due of 6 lakhs only, the due is not 6 lakhs, the due is much more. Are you trying to say that the total dues you are not aware at that time, you are only aware of 647? Because this due cannot be in a, what do you call, a piecemeal basis. It is not, if the due is 50, more than 15 lakhs, it will be more than 15 lakhs. No, let us not go into the let us not digress let us not digress of the main issue. Now, are you, madam, can you
Explain.
Can you, no, you just need to show us some documents or some, that when is this 647 was cleared to the taxation department? Then we can send the matter back.
No.
You examine,
May I
if they have
submit, my
cleared,
lord?
then release
Yes.
it.
Initially, my lord, what happened? They did not pay the tax because the petition was pending for eligibility certificate. If they would have got the case, my lord, in their favor, they would not have paid this amount. So, my lord, they have delayed in payment. Thereafter, my lord, when the case was taking long time, that's why they were forced to pay the amount. So they have paid. Otherwise, my lord, once the registration is made and illicit certificate was issued in time, the money they could have saved. But due to some, anyway, my lord, misfortune, they have to pay this amount. And out of this, my lord, several amount was paid through net fee.
We'll do one thing.
Paid
You,
through net
have
fee.
you given a copy of this to Mr. Das or
Yes,
Mr.
yes.
Please, both of you can take instructions on this. Though you are not representing the taxation department, you can communicate whether this due which you had retained of 647 has been cleared. If it is cleared, then we can pass orders. Then also you can verify. Give your instructions that something has been done, then we'll send it to you.
Now, as per my instruction, no dues is
That is it.
pending. They have paid the
Actually,
entire amount.
About it. Yes, yes. Yes, yes. Yes, yes. Mm. Mm.
Go to the next page. Hello?
No, we can dispose of this petition also
Yes,
with
fine.
this order. Have a look. What we have, this is the draft. Mr. Kolita, have a look. We have not recorded your consent. We have said that you don't have concrete instructions. Okay, okay. I think this is good enough. Whatever documents she has, she can give it. You verify if she is entitled to it.
Secondly,
Okay, okay, okay.
yes.
Take, oh. We'll just make some correction. This is the draft.
Yes, ma'am.
Okay, dispose of.
After submitting the documents, they should release the amount immediately.
No, if it is found to be entitled.
Yes.
Huh. And the
Then
matter may be
immediately.
examined thereafter, appropriate steps be taken for release of the balance amount. Appropriate order is also required to pass a speaking order. This we have said because in case you have a different opinion, then you can have a speaking order.
Then they have to.
How many, what, within a month from the date of receipt? We had given 15 days for you. We don't need 15 days, I think. You submit within 10.
1 week.
You submit in 7 days, they will do it within next 3 weeks. 4 weeks, okay.
Already amount is on the account.
Period of 27 days. Period of. Oh. The appropriate are also record to process the entire exercise.
Only one thing more, my lord. Because there are, my lord, in certain cases, interest has been paid on transport subsidy. And my lord,
Interest part is pending in the Supreme Court.
yes, this court is allowed, and my lord, matter is pending before Supreme Court, Honorable Supreme Court. So my prayer is also for interest. So that may be kept open. Otherwise, I
That
will
is
come for
already
you,
open.
Judicata.
You can always come.
Open one line, my lord.
The entire exercise.
হ'ব দিয়া, তোমাৰ কি আছে? Only one line tip will be open.
First, you have to get this amount, then interest will come.
Only my lord, open my
Okay.
lord, one line may be given, otherwise
That-
they will
that-
catch me for
see, it's in the
adjudicator.
Supreme Court, whether we say or we not say, that is already open for you. Okay, next.
Adjudicator will not come. That's what. For petty amount, they have to wait for.
Yes, next.
I don't know, I have to put it. It will-
13.
it will- it will- it will-
5.
Four to
5 is different.
seven.
5 is different, I think. 5. Oh, no.
Party same issues regarding eligibility certificate. Why
No,
have
I
to-
think it's, 5 has to be
Five is-
adjudicated separately, or
Yes, yes. It has to be a-
wait, can we
It's
do it
separate.
today, now? Now? 5?
As a-
very small.
5 we can take up to. Get to
Take
4
more than, 15 minutes. Within 15 minutes, your lordship can dispose of my lord.
Okay, 5.
Petitioner, my lord, in pursuance of my lord, a policy. They have
What do you
filed-
manufacture?
Say roller floor mill at present, my lord, atta, suji, moida, all these things.
Okay.
It's a roll-out floor.
Okay.
Earlier, when the policy came, my lord, in 97, my lord. Few paragraphs are-
97, there is a policy.
97 policy, my lord, the roller floor mill was, my lord, was in the positive list to get,
No,
no, 97, it was, my lord, positive list, but 2003, my lord, 2003 to 8, that 5 years policy, the roller floor mill has come into negative list,
2000?
3 to 2008. That policy, it has come in the negative list. Earlier, my lord, 97 to 2003, the policy, my lord, that was in the positive list.
You were eligible, that means.
Earlier,
That means you are
earlier-
eligible till you
Yes,
say
ma'am.
that to 2003,
Yes,
you
ma'am.
are eligible.
Yes. So, my lord, in pursuance of the 97 policy, they have applied paragraph 5, page 6, my lord. The company applied for registration of the policy. It was registration
Page
was done.
6,
Page 6, my lord. The petitioner only begs to state that the promise made by the
Paragraph?
company of- Paragraph 5. Various fiscal benefits of the upcoming industry, the directors of the petitioner company decided to set up a floor mill at Tinsukia district after taking bank loan of approximately so-and-so, term loan of so-and-so, and on various sources, and started the primary work for setting up the floor mill in the year 2002. However, the commercial production of the petitioner company commenced on 16/6/2004. So I have come in the negative. But my lord, it was, floor mill was, my lord, in the positive list. It is important to note that although the industrial unit was initiated to set up in the year 2002, before the commercial production started, the benefit under Assam Industrial Policy of 1997 has been left along with the 5-year plan, and a new policy along with the 5-year plan has been announced by the government of Assam. The petitioner company begs to state that the government of Assam, by notification dated so-and-so, was pleased to announce a policy named Industrial Policy of Assam 2003 after the lapse of Assam Industrial Policy 97. This industrial policy has been introduced by the government of Assam with the only intention promotion of growth industrial unit as well as for expansion of existing unit, giving a fiscal benefit. The petitioner company begs to state that after going through the terms and conditions laid down in the above mentioned policies, the petitioner company had applied for registration as SSI unit under the Industrial Policy of Assam 2003. The petitioner company further filed letter written to the General Manager Tinsukia for clarification of the subsidies available on the agro-based food procuring industries and requested to advise how to register the industry in the department. Accordingly, the petitioner that the petitioner company has also applied along with all necessary documents to the General Manager District Industries and Commerce Center Tinsukia for issuing a permanent registration of the unit. Then the General Manager Tinsukia, after field verification and proper scrutiny of the papers, being satisfied, issued to the petitioner company the permanent registration certificate of SSI unit on 2004 as 4 mil. Registration was done as 4 mil, not my lord, roller from. That the petitioner company begs to state that accordingly, with a view to get the benefit of the above mentioned policy, namely so and so, hereinafter referred to as policy, the petitioner applied on 15 December 2005 to the concerned authority in standard format along with all necessary documents and particulars following the terms and conditions of the policy which has been received by the department. In the standard application, the petitioner has given all necessary details as it has fulfilled all the criteria and conditions laid down in the notification dated 26 September 2003 and verified by the department. The petitioner company states that the
Tell
petition-
us the issue, madam. No
Yes,
need of,
my lord.
no need
So,
to.
my lord, they have, unluckily, my lord, they, by that time they start, but they have applied for 4 mills, not for roller from. But my lord, 4 mills was at that time also, in 2003 also, it was, my lord, entitled for the benefit. And subsequently, my lord, the roller from mill, my lord, I will show your lordship, roller from mill was in the negative list. But since the petitioner has not put the criteria for the roller from mills, they have to put certain roller in the mill. But the petitioner has not put negative list, that is, my lord, in page 31. Is a negative list, is there will be certificate. So, anyway, my lord, roller from mill was in the negative list. That is
Where,
not
page
disputed.
31, where?
Not 31, my lord, other page. It is 38, page 38.
Page 38.
8, my lord. Function of the committee, schedule 1, my lord,
Hmm.
that number 3, roller from it, that
Yes.
is in the negative list. But my mill was floor mill. That was my lord.
Yours is a floor mill or roller floor mill?
Earlier it was, initially it was floor mill. A registration was done as floor mill and it was floor mill. Subsequently, my lord, I have, after 2008, my lord, I have set up this
Roller.
more roller.
Where are the documents to show that
Uh,
initially it was a floor mill?
They have applied as a floor mill. my lord.
Where?
The application, my lord. Documents in this certificate necessary. That was a list self-protection. Lord.
Once.
I misplaced the file, my lord. Still, I could not get it. So I have all papers. No, this file, I particularly lost this file. But that's why I'm little bit
You have not lost the case.
lost the case, my lord. But I have taken copy
Why
from
is
him,
it an
my lord.
indication of losing the
Wait,
case
wait.
also?
Because everything was marked, all documents, I could not,
Mhm.
I don't know whether they have left it on a court or where. Not 4 mil. Yeah, okay. Other than 26, my lord, I will require more document because, my lord, I have lost the file, my lord.
Mr. Kolita, where is that reference to the schedule in the main policy? Well, 38 is the schedule, but where is the reference to the schedule?
97 policy. It starts from 23, my lord.
No, that we have started. Where is the reference to schedule 1? 4.3.
2003 policy.
43. 20. Means,
Is
okay,
50 also there. List of non-eligible unit.
No, that is okay. No. That is absolutely okay. This is the policy of Assam, 2003 policy, 3 policy. No, but no, this is 2003 policy. Page starts at page 39.
Yes.
Page
3. No, that is exactly what we're trying to understand. At page 38, if you come to page 38, that you find a schedule 1, and it's generally you have considered it is a negative list.
negative.
No, where is schedule 1? Above this? 29. Okay. Right. You're correct. Schedule 1. Non-eligible unit, all industries. Okay. Okay. Page C29. See page 29. 29. Okay. Rural floor mill was never in one of the eligible units.
Yes.
Okay. Now you
Since
have to show a
2008.
document. You have to show any document to establish that yours is not a rural floor mill, it's a floor mill, and maybe in 2008 you had
Yes,
made
sir.
it rural.
Yes.
That's a different which you are
Different.
contending. Where?
Which are tornado.
6.5. Correct. Yes. Correct or not? Yes. Or Justice Kotoki's order?
Yes, ma'am.
Yes.
But nobody visited. I have written in the petition, my lord, nobody visited their unit after the order. Earlier also first one.
Order in WPC. This was WPC what? 5199.
Yes,
2012. Yes. Where is the operative portion? 66. Yes.
Main question.
In view of the
which
disposal
requires-
petition of the ruler, exactly, yes. So we do not go back to those issues. 66. Direction
Okay.
to inquire whether it is a roller floor mill or okay. Page 68.
Yes.
5913.
Yes.
This is impugned. Okay. Where is the High Court order so and so whether Your original application itself states that it was rural floor mill.
Floor mill, my lord.
The project report they have submitted, we have submitted. We have given the project report that they have submitted.
Page.
In the affidavit for.
By Professor Kumar Swikia.
Yes, my lord, yes.
Page 9 is.
Just a minute. Page 9. Yes.
Various mentions about various spaces where we have mentioned products. So first also we find the product is uses in market prospective is 15.
1.5.
One. So you number 3.02. So we find at line number 4. To support this cost, border from bills where are being set up. Then the main.
In all
product
parts of
border
the
field
country.
are data. All everywhere in the document, so you can using this. But they are going to they are basically aspects of rural firms, how rural firms work, what are the products, the products mix. And phase 23 define the capacity of the proposed modern solar firm. Phase 23.
Yeah.
Production capacity, the first line that they have done, they have written.
20, page 23.
Phase 20. The capacity of the proposed modern solar floor mill. So their basic project document, which has been submitted for this thing. The application is accepted from. Now they cannot go back and see the. In fact, try to do. It is not a product from its,
You come to page 47.
yes.
That list, number 6.
Product from. But there's a very decent document.
Page 120.
You will also may give me answers, otherwise I will withdraw the petition, ma'am. Because
Page 120.
I'll not.
Obviously, you perhaps you are not aware. Come, madam, please come to 120 also. 120. 120. I mean, not 120, you will be page 40.
Yes.
13, number 13.
Some 11. I will withdraw the petition.
Okay.
You have.
That's.
Okay, we'll have it on Tuesday as part of.
Yes.
You take instructions. You can
Tuesday, my lord.
instruct.
Otherwise, if that is so, what I have got here, then I will withdraw this petition, I will not appear.
Okay.
Because in their application,
Wednesday.
that is Thursday, Kota case, another case. is
The other case is on Thursday.
Thursday, what? Next Thursday.
See.
Apa tu? Ya.
23rd, this court will not be here. 23rd, this court will not be here. It cannot be parted.
Before that, before.
12th, yes. Okay.
12.
Okay, no problem. Well, 11th, what about 11th?
11 is.
No, we'll accommodate you.
Yes.
Only for this,
11.
she'll take instructions.
Yes.
If she's got the instruction, then
Yes,
she may
sir.
withdraw this
If it
case
is not,
also.
I will withdraw this case. That will not think.
Okay, we'll accommodate you. If there is any need, we'll postpone it 11th. Heard. MS and Sakya, Learned Counsel for the petitioner. Para also heard Sri A. Kolita, Learned Standing Counsel, Industrial and Commerce Department. Full stop. The petitioner has put to challenge the legality
Okay.
and correctness of an order dated 5/9/2013 passed by the department. Full stop. The said order has been passed pursuant to a direction dated 23/4/2013 passed by this court in WPC 5199 of 2012. Full stop. Para. By the impugned order, comma, the claim for subsidy of the petitioner company has been rejected on the ground that the unit comes under the negative list of the policy and therefore not entitled to any subsidy, full stop. To be precise, comma, it has been held that the petitioner's unit is a roller floor mill and not a floor mill. Inverted comma, roller floor mill and not a floor mill. Full stop. Para. Sri Kolita, the Learned Standing Counsel, has referred to a number of documents which are part of the proceedings to contend that the unit is in fact a roller floor mill and therefore the speaking order does not suffer from any infirmity. Full stop. Para. MS Saikya, the Learned Counsel for the petitioner, submits that some time may be granted to enable her to obtain instructions on this aspect. Full stop. Para. List as parted on
11.
11th.
Let's.
Mata. আছে মানে আছে এইটো চাব নালাগে মাতা আমি যদি সময় ল'ব
Click on another date, your lordship, because Mr. Chaudhary is on like in the part matter.
other side you have some urgency. Tuesday.
Coming
Yes.
11th lordship Thursday.
Tuesday have a difficulty or what? What? You'll be, he's there or not?
He's here, lordship, but
We'll accommodate.
Document fees.
We'll accommodate. Prayer for adjournment has been made on behalf of Sri K.N. Choril and Senior Counsel for the petitioner. Full stop. Para Sri S. Bothakur, Learned Counsel for the which corporation? Huh? BPCL, however, expresses urgency. Full stop. Para. List on 9th.
interim order.
Para interim order passed earlier to continue till the next date of listing. (15 to 17). Yes. Okay, you have evaluated. Okay. Put it. Mr. Sharma, what is your name? Prabhat.
Prabhat, on two accounts, Your Lordship, for micronutrients and for biofertilizers, and MD Biocol, who did not participate eventually in pesticides and weedicides, they participated for micronutrients. So there are three petitioners, in fact, Your Lordship.
Prabhat is for?
Prabhat is for micronutrients and biofertilizers.
Okay, wait just a minute.
Yes.
For micronutrients.
Yes.
Micronutrients.
Micronutrients, Your Lordship, is 6588.
Biofertilizer.
For biofertilizers, Your Lordship,
Just a minute. Just a minute.
yes.
You have two petitions by Prabhat.
Yes, two petitions by Prabhat, 6588 and 6589.
6588,
And
6589. Prabhat.
Yes.
One for?
One is for, the first one is, Your Lordship, for micronutrients.
Nutrients.
The second is for biofertilizers. Yes, 6589.
And the other one?
MD Biocol is for weedicides and pesticides. 6591.
6591 MD.
MD Biocol.
Biocol.
Yes.
For?
For weedicides and pesticides, Your Lordship.
Different items.
Different items, Your Lordship. Now, what has happened?
No. And pesticides.
Weedicides and pesticides. This is what the writ petition pertains to. But MD Biocol, for some difficulty on their part, they participated for micronutrients.
Okay.
Again, that is riding on the order of this honorable court that the manufacturers.
Okay.
Yes. Your Lordship will be, I think it will be slightly helpful if Your Lordship can take up.
Just a minute. There are three items.
There are three items.
Micro, nutrients, biofertilizers.
And weedicides and pesticides.
Weedicides and pesticides is one item.
Yes, that is one item. Now, Your Lordship has this technical assessment in front of Your Lordship.
Just a minute.
Yes. Now,
fertilizer. No, I'm just asking on generally to both of you.
Yes.
See, these are the three items in a broad manner.
Yes, three items in a broad manner.
But so far as suppose, what is this?
That Your Lordship would be clear.
Micronutrients is concerned, for example, there are various items.
Yes, absolutely. Your Lordship
Zinc sulfate is there, borax is there. So,
yes, it will be reflected. Your Lordship has just gotten hold of the three newspapers. Your Lordship will kindly come to page 3, Your Lord. The second slot, page 3. Your Lordship has finds that, Your Lordship.
Which document? Some tenders, which one?
The tender, Your Lord. The technical assessment. Sir, आपने delay मत because आपने just delay the three staple lots.
Yes.
Page 3.
Of any one of them?
No, just page 3. Your Lordship, I've
page 3, okay.
Yes. This is for micronutrient. Page 3 is for micronutrient.
Just a minute.
Yes. Page 3 is for micronutrient.
Where do you get it?
Your Lordship, the third line.
Okay, micronutrient, okay.
Now, Prabhat's name features at serial number 11.
Yes.
Technically qualified.
Yes.
Then Your Lordship would come to page 4D. 4D.
Yes.
4D. Yes.
4D,
11. Your Lordship sees the product is zinc sulfate heptahydrate.
Yes.
Responsive in view of this honorable court's order.
Oh. Okay.
Yes. So, Now, if your lordship would come to page 4E, which is the immediately subsequent page.
Yes.
Yes.
Hmm.
This is the product name, your lordship, which has been again re-verified. Zinc
Which one?
sulfate heptahydrate.
4E.
4E. 4E.
Yes, yes, yes.
Yes. The first serial number.
Hmm.
That is the product, specific product on
Yes,
the product
yes.
category. Yes.
Now, what is this? What are you trying to show in page 4E?
4E, again, nothing, your lordship. This is a table, which
Okay.
is a summary.
You are
summarizing-
interested in zinc,
Yes,
so
yes,
far as zinc
yes.
sulfate is concerned, Prabhat is also one of the bidders.
Yes, yes, yes.
Now, what was the order we had passed?
Yes, your lordship.
Okay, subject matter. Oh, right. Subject.
Yes.
But with all the requirements, the court has,
The order is
and
dated
I'm sorry to
1711.
go ahead with the opening of the financial business. So,
Correct.
okay. Well, our intention is that if they fail in the financial bid, then there is no requirement to examine the issue. But if they are found to be L1, then for those products at least, we can examine, others we can let you go, isn't it? Okay, we'll see.
Also, your lordship, I just interrupt your lordship slightly here.
yes.
So what has happened here is that the government has been is magnanimous in this manner that they have not just permitted the petitioners, but they have also permitted similarly situated manufacturers to participate.
Yes.
Now, just as an example, your lordship would see there are other parties also who have joined the fray and who have been termed as responsible.
Yes.
Now, this matter may not be confined to only the petitioners. This is just a humble submission, because if the matter goes only strictly terming the order, then the other manufacturers also would go. So, the lordship may also need to probably address the issue of whether the supply certificate is necessary or not, because other similarly situated manufacturers have also joined the fray. I can give an example also, your lordship, which yes, absolutely. Yes.
No, Mr. Chaudhary, are you sticking to the eligibility criteria, or have you diluted that requirement?
terms of the interim model lodging, we have not taken.
No, that is different. We have asked you to evaluate. That's a different matter. That's by the orders of the court. That is only to see whether how much is their financial strength. But otherwise, are you still sticking with that, or that needs to be adjudicated? Whether it's okay.
Because
No, what will happen now? See, we may not be too much inclined to accept your submission, Mr. Sharma, but there will be one more thing. Now, he comes before the court. We are not going to examine the issue of somebody who is not before the court. Now, he raises an issue that allow me to participate, in spite of the fact that I have not fulfilled this particular requirement. Whether that requirement is justified or not, we are yet to decide. Now, because of the interim order, you have also allowed others to participate. Now, amongst the others, and the financial evaluation has been done, we will not disclose who is L1, who is L2. But suppose, other than the petitioner, somebody who is similarly placed than the petitioner is also as L1. Then in that condition, what will you do? No, that is okay. No.
Technically, that's subject to that part.
No, Mr. Chaudhary, Mr. Chaudhary, please understand. Please understand what we are trying to. We are trying to help you, help the department. We don't want to stall this kind of proceedings. We wanted to know that if the petitioner is not amongst the L1, then we will not decide. Go ahead. But taking, I will not say advantage, in view of the court's order and in view of the corrigendum which you have said, other similarly placed persons who were initially not eligible, they have also participated and you have accepted there to be technically responsive. If they are amongst the L1 bidders, what will be the consequence? Without issuing, adjudicating the legality of that particular eligibility clause.
That we are there's a
Then the second question, immediate question will be upon you. See, you are the administrator. It is your prerogative, your discretion, how to get the things done in the best possible manner without there being any arbitrariness or unreasonableness. Now, without sticking to this particular requirement as a technical qualification, will you face a grave difficulty in getting the things executed? See, we will not want to disclose this, what is in the seal cover, who's L1, who's L2. We find that petitioners in from few cases may be L1. Those cases we may put on hold. But if we allow you to go with the others, even those may be L1 who are not who are not technically qualified as per the original bid. Can you do one thing? These are your documents. Amongst all the L1 bidders, except the petitioners, are there anyone who are similarly placed there like that of the petitioners?
There are.
If there are not similarly placed, if they are otherwise eligible as per the original document, we'll allow you to proceed with them. I think we have to balance everything. We don't want to put this kind of a supply situation to put on hold. We can have it tomorrow. You examine this thing, because and it is also you know it better. Though apparently there are 3 items, but under every item there are around 4 sub items, and L1 has to be in context of those sub items. Okay. When can we have? Tomorrow? Tomorrow. At least few we can modify the interim order.
In fact, the main problem here, as the Lordship has rightly pointed out, happens in the last category of weedicides and pesticides. There are multiple other manufacturers who have.
No, we do not know which L1 is similarly placed like or which L1 was otherwise technically qualified.
Yes.
You just need to, you sit with your officer and you. In terms of the last order dated 20/12/2023, Sri B. Chaudhary, Learned Standing Council, Agriculture Department, has placed before this court the result of the financial evaluation in a seal cover. Full stop. In a seal cover envelope, full stop. The envelope has been opened and it is seen that among the broad 3 items, namely number 1, micronutrients, number 2, biofertilizers, number 3, weedicides and pesticides, there are a number of subheads for which separate bids have been offered. Full stop. This court has also been apprised that in terms of the interim direction of this court, a corrigendum was issued enabling parties who did not fulfill the requirement, which is the subject matter of challenge, had also participated. Full stop. It is therefore required to be seen as to whether any of such participants who are similarly placed like that of the petitioner are also amongst the L1 bidder. Full stop. Para. Sri Chaudhary, the Learned Standing Council, is accordingly directed to take necessary instructions in this regard so that suitable modifications can be done with the interim order as the items which are the subject matter of supply and these litigations are of essential nature and are to be completed as expeditiously as possible. Full stop. List again tomorrow. Para. Tomorrow. We'll make a mention. Para. Let a copy of this order be furnished to Sri Chaudhary during the course of the day. Full stop. To facilitate the understanding council to have adequate instructions, comma, the evaluation sheets which were presented to this court in a seal cover are returned back. Yeah, we merge it, yeah. We'll give you the copy. Please collect it from the court master.
Tomorrow, this honorable court will address the issue, the legal issue which is here under.
No. We'll only modify the interim order. Where you are not at all connected or where persons similarly placed like you are not among the L1, they can go ahead.
So for tomorrow's adjudication, your
Yes.
lordship will go into the issue which has been assailed in the writ petition.
No.
Okay.
Only on that part, clarifying. Yes.
I'm grateful, sir.
Item 23. Hearing.
May.
Yes.
My lord, before I proceed, my lord, the brief issue that is involved.
Yes, madam. Who is your senior? Digolita, for which department?
My lord, he is for a private respondent.
Okay,
In whose
and
favor
Chetia for
the
government. This is fishery department or what? Okay. Yes, when can we do? For how many years?
My lord, this issue actually is relating to
No,
my
for how many years? The tenure?
tenure had already expired, my lord.
Okay.
I am challenging the extension that has been granted to the lessee without, my lord, following the process number 1 and without
Okay, Tuesday, ask your senior to be here.
use
Okay.
them, my lord, with. My lord, it would be, I think,
11th, I think. Or 9th.
no, just one,
Okay, 9th.
because I have some urgency.
Third Sri age, those Sri age Burago Hai. Then counsel for the petitioner is present. Along with Sri M, as well as Sri M. Chetia, Leonard State Council, comma. A prayer for adjournment has been made on behalf of Sri D. Kolita, Leonard Council for a private respondent. Number
8 months.
8. Put the para. List. In view of the above, list for hearing on 9/1.
I'm highly obliged.